Defendant, Ms. Luczynski, is present to my right. Can you please state your name for the court this morning? Christine Luczynski.
All right, so she is going to plead guilty to the charge of operating while impaired. They're going to dismiss the original charge, correct?
That is correct, Your Honor.
All right, Ms. Luczynski, is that what you would like to do, ma'am?
Yep.
If you plead guilty to operating while impaired, I'm going to dismiss the operating while intoxicated. The possible penalties are up to $300 in fines, 93 days jail, 360 hours community service, court costs, or all of those, 4 points, license suspension or revocation in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or a trial by jury. At a trial, you'd have the right to remain silent or testify. If you remain silent, that silence would not be held against you. If you plead guilty, you're giving up all those rights. You're giving up the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt, and there will be no trial of any kind. Do you understand that?
Yes.
To the charge of operating while visibly impaired, how do you wish to plead?
Guilty.
Were you operating a motor vehicle on January 7th of 26 at 10:04 p.m. on Gibraltar near Mayfair in the city of Flat Rock?
Yes.
Did you drink alcohol prior to that? And what did you drink and how much?
Yes. Approximately 6 beers.
All right. And why were you pulled over by the police? It says on the citation you were swerving between lanes of travel. Do you agree with that?
Yes, swerving.
You think you were swerving at least in part because of your alcohol consumption?
Yes.
And there was a blood test that revealed 0.147. Do you stipulate that that was accurate for purposes of the plea, Ms. Aycock?
Yes, we would still stipulate. Thank you.
Are you on probation or parole, ma'am?
No.
Anybody force you to plead guilty?
No.
All right, I'm going to accept your plea. I'll dismiss the operating while intoxicated, refer you for a screening and assessment. You're going to be screened and assessed today, and then you'll be sentenced at a later time, okay? So we'll give you that date, and then you'll have to come up here and fill out a questionnaire and be interviewed by the probation department. What do you have for me, Heather?
We could do this on oh my goodness, May 28th at 8:30.
Is that good with you, Ms. Aycock?
I have a circuit court PPO hearing at 10, and that is
I'll have
in
you out of
person
here at
downtown.
8:30. I'll have you out of here if you can do it. If not, we'll give you another date.
Yeah, as long as I can get downtown by 10.
Yeah, okay, we'll make it 8:30 in the morning, okay? And again, you can be there if you'd like, or you can both come in as long as you're in the same location, all right?
Thank you, Your Honor.
Have a good day. Thank you. Good luck, man.
Thank you.
All right, people against Robertson, Jeremy Robertson, file number 25WA37064. Your name? On March 4 of 26, I sentenced you. There was $1,831 to be paid, including restitution to Lowe's in the amount of $1,146. Let's see. I also allowed you to pay that at the rate of $150 bi-weekly beginning March the 13th. The charge that I have in front of me alleges that you failed to pay your fines and costs as ordered. $1,831. Do you understand that? Yes, sir. Did you sign, read, and understand an advice of rights form? Yes, sir. If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial of any kind. Do you understand that? You have the right to a lawyer. I'll be happy to give you one at public expense. Do you understand that? Yes. Would you like a lawyer? Yes. Are those sunglasses or what are those? I can't hear you.
Here's triangles.
I still didn't. Okay. Yeah, I'd encourage you not to have those on when you come back unless you need them for vision, okay? All right, so I will go ahead and enter a not guilty plea. I'm gonna give you a lawyer. And, we will go from there. So I'm entering a not guilty plea. We'll give you a probation lawyer. You'll meet with them. Either way, you're coming back in front of me, okay? Any questions? I can't hear you. Just need to keep your voice up, okay? Good luck. People against Scott Joseph Hires 26G307010. Your name, sir?
Tired.
All right, so they're offering you impeding traffic. Do you want to plead to impeding traffic?
Yes, sir.
You got one prior to that charge of impeding traffic. You plead responsible or not responsible? I'm gonna accept your plea of responsibility. You got one prior, $160 is the total. I'll dismiss the disregard stop sign. Be careful, okay?
Yes, sir. Thank you.
Thank you. You can go right down the hall and make your payment.
Thank you.
People against Daniel M. Mace, 26G306969. Morning, Mr. Mace. Your name?
Anyone else?
All right, so the charge here is speeding. All right, let me just check. All right, so you're gonna plead to impeding, correct?
Yes, Chairman.
All right, to that charge, responsible or not responsible?
Possible.
All right, I'll accept the plea. You've got, it looks like no priors. 150 is your total. Cash you into the hall to your right. Have a good day.
Thank you.
You. People against, Dominic Fioretto. 26G307011. All right, your name?
Dominic Fioretto.
All right. Yeah, an accident a year ago, right? You're gonna plead to impeding. They're going to dismiss the stop sign violation, true?
Yes.
And that's what you want to do?
Yes, sir.
To the charge of impeding traffic, responsible or not responsible? I'll accept the plea. 160 is your total. Cash you into the hall to your right, and you're all set. Have a good day. Good luck. Chestnut. Elvin Daniil Chestnut II, 26T648303 A, B, and C. Could I have Keith Gross seated at the table, my right, your left? Sir, your name?
Oh, Chestnut.
You're charged with driving on a suspended and expired plate and no proof of insurance. You have the right to a lawyer on these. If you want one, I'll give you one. Do you want a lawyer?
Yeah.
Okay. Okay, it's just gonna take a little bit of time.
Don't even want blood.
Okay, so I can arraign you. I'll explain the charge, the possible penalties and your rights, and then you can go talk to the prosecutor, okay? On April 13 of 26, it is alleged that you did operate a motor vehicle on Fort near Harrison and Trenton at 5:05 PM with a suspended license. That is a misdemeanor. It is punishable by up to $500 fines, 93 days jail, costs, or all those 2 points. Do you understand that? You also have an expired plate and no proof of insurance, 0-point civil infraction charges. Do you understand that?
Yes.
Did you sign, read, and understand the advice of rights form? You plead guilty, you will be giving up all those rights, and we will not have a hearing or a trial. Do you understand that? You understand that? You still wish to waive your right to a lawyer?
Yeah.
All right, I'll enter a not guilty plea. I'm going to have them give this to the prosecutor. And he will call you in, okay? Any questions? Good luck. Keith Allen Gross, 26G82668. Come on to the podium, sir. It's all right. Your name?
Keith Gross.
Okay, so you're charged with failure to respond to a civil infraction. So apparently they issued a civil infraction, they think, and you didn't respond in any form or fashion, so they filed a misdemeanor charge. The charge is a criminal charge from failure to respond to a civil infraction. It is punishable by up to $100 fines, 90 days jail, costs, or all those. Do you understand?
Yes, sir.
You have the right to a lawyer. If you want one, I'll give you one now.
I don't get water.
Okay, they think that this happened at Mar Street, 30348 Mar, in the city of Gibraltar, February 17 of 26. It says they issued you a civil infraction on January the 28th. And that was for failure to clear snow from a public sidewalk after being warned previously. So this is a misdemeanor, punishable by up to $100 in fines, 90 days jail, costs, or all those. Do you understand that?
Yes,
Did you sign, read, and understand the advice of rights?
yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing with a trial of any kind. You understand that?
Yes.
All right. You still wish to waive your right to a lawyer?
I do.
Not guilty plea, I will enter. I'm going to give you $100 personal bond. You don't have to post any money. Here are your bond conditions. You cannot leave the state without the consent of the court. Violate the law. You must appear in court as directed. Okay? So you go move down the hall. We're going to give this to the Gibraltar prosecutor. He will call you in when he is ready. Okay?
Judge, can I say something? We spend our winters here in Florida. And we were just made aware of this one day.
Go explain that to him. Okay?
Thank you.
Go explain that to him. All right? I don't know what happened here, but
Well, the son resides at the house and when we finally called him after I got the paperwork, yes, Dad, I did get cited for it. Why didn't you pay it? Well, I don't know.
I see. So your son did this to you.
Yes.
See?
Gotta love it.
You and I are about a month apart, okay? I look at your birthday. That's what happens, isn't it? Go talk, explain your situation to the prosecutor. All right?
Down the hall.
No, right outside there, Gibraltar, you're gonna go to conference room number 3. So that's gonna be right outside the doorway there, and then to your right on those pews, okay? Thank you, Julia Ann McCormick, 26T64678. Nathaniel Mays, you can have a seat up at the table here. Nathaniel Mays, ma'am, your name?
Julia.
All right, you're charged with operating with the presence of drugs. You have the right to an attorney. Would you like one? I'll set you up with a lawyer, okay? So just go out in the hallway. They're going to be backed up, so it may take a little bit, but just be patient, okay? Thank you. Nathaniel David Hayes, 25T643636. Where's Mr. Hayes at? Yeah, you know, was this guy notified to be here?
Hayes, was that the name? Oh, yeah, there.
To review hearing.
You didn't check down with me.
Did we not issue a show cause? The last time that he wasn't here, I don't dismiss these unless they show up. So he wasn't here April 23. And I said, issue show cause regarding why conviction should not enter for failure to appear for review. I'm not going to get in the habit of having these guys sit home. So I don't see where a show cause was issued, Heather.
Sorry, it was issued for today with the review. I'm sorry, I didn't put your name after it, but today was a show cause in a review hearing. We put it together.
I just, if you didn't, that's okay. I mean,
No,
I just.
it is showing in here, Judge. I just didn't put the M after it. So the show cause was issued with the
Just
review.
don't see one in the file, though. I
Oh,
don't
the
see a.
note- Oh, from probation?
Well, whoever's issuing the show causes, I believe it's them. Right?
Because I scheduled it for a show cause hearing after he didn't show on the
Okay, but-
23rd.
Did you actually prepare a written show cause? Because I don't
No.
see. Pardon?
No, I just did the scheduling for it.
Somebody needs to do that, okay? So when you
Okay.
talk to Lisa, I don't know if I hate to end this conviction. It looks like he did what he was supposed to do, but I just don't want to get in the habit, absent extraordinary circumstances, of dismissing these without these guys showing up. So I'm going to have them issue a show cause, and I will issue it, just have them take this to Lisa and have her look at my language on April 23. I don't remember if you guys do it. I think probation does it.
Yeah, probation. I'll have them do it.
Yeah, okay, so reschedule that if you would, okay?
Okay.
Thanks. Sir, what is your name again? You have to unmute, yes.
That's Anthony Stefani.
Anthony Joseph Stefani, sir.
In here for today, Heather.
Joe calls.
Show cause?
Yes.
Yes, I'm sorry, Judge. I thought I was unmuted. He's a show cause today.
Is it a show cause where you never pled before on a probation violation or what?
It's a probation, yes. Miss Wilds had me requested this show cause for him today. So is there a blue back in there
Is it in here?
or a written?
Oh, okay,
or
I see.
written
I'm
show
gonna
cause?
call that Stefani. This is people against Anthony Joseph Stefani, 25W701-244. Your name?
Anthony Joseph Stefani, sir.
I believe you had a lawyer when I was in here, when you were in here on December 22nd, but that was with respect to another show cause. And now I thought we talked about this, but I'm gonna go ahead and arraign you on this new charge and give you a lawyer if you would like one, okay?
All right, sir.
All right, so you are charged, first of all, this is a domestic violence case. And
This is,
I'm sorry?
I believe it was, I believe I went to court over this before. I was supposed to pay some money and then show back up to you, and I missed that court date because I was in the hospital.
Slow down. Let me just tell you what happened, okay? You
Yes,
pled
sir.
guilty to domestic violence back on March 4th of 25. I sentenced you on this on March 18th of 25. This show cause here alleges that you violated probation in the following aspects. Count one, that you failed to attend the domestic violence program with an 8-week follow-up. Do you understand the charge?
Yes, sir.
Count two alleges you failed to pay your fines and costs. I thought we talked about that. And that you have a balance owing of $1,040. Do you understand the charge?
Yes, sir.
If you plead guilty or if you were found guilty, you could get 5 days on each one of these counts, so you could receive 10 days on this. Do you understand that?
Yes, sir.
You are presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses. They have to prove that you violated probation by a preponderance of the evidence. If they fail to prove that, then the charge would be dismissed or you'd be found not guilty. If they do prove that, then you're subject to a 10-day jail term on this. Do you understand that?
Yes, sir.
You have the right to an attorney. I'll be happy to provide you with one at public expense. Do you understand that?
Yes, sir.
Likely lawyer.
No, sir.
Are you sure?
Well, I thought this was just an arraignment.
This is an arraignment. I'm either going to ask you how you plead or I'm going to give you a lawyer.
I guess I'll have the lawyer then, sir.
I'm not trying to talk you into it. If you want to represent yourself, that's fine by me.
No,
but-
no, I was a bit, I must have misunderstood.
Okay, I'll enter a not guilty plea. I'm gonna give you a lawyer. We're gonna set them up with you in a breakout room so you can speak with them now, and let's try to expedite that for the county if we can, whoever the lawyer is, John. With this gentleman, I want him to get a lawyer as soon as possible, okay? All right, just bear with us. I'm entering a not guilty plea. We'll give you a defense lawyer. Drew Aaron Gerald Jr. I have two files here. I have 26B150241A and B. Good morning, Mr. Granata.
Good morning, Ron. Peter Granata, P78413, MIDC counselor for Mr. Gerald. You just take the name for the record? Drew Gerald.
All right, give me 1 second here, okay, please? All right. Your client was in court. He pled guilty on April the 16th, operating while visibly impaired. He also pled guilty to possession of controlled substance. This was cocaine under section 7411. He was referred for a screening and assessment. They had the opportunity to review the report with him, and are there any material additions, corrections, or deletions?
I did review the report with Mr. Gerald, and we have no additions, subtractions, or changes.
All right, anything that you would like to say on his behalf?
Your Honor, I just would like to say that as far as Mr. Gerald is going, he's working 50, 60 hours a week, but he understands that he's got to make this commitment to get done everything that's in the probation report. He would only ask the court if you would consider allowing him to do community service instead of a court work program. If the court was willing to assign him the court work program, he's been in touch with a couple of nonprofits in his area. He's got a line on being able to get the community service done if the court decides that the work program could be opposed.
He lives in Taylor, right?
Yes.
Okay. Anything else?
Here.
Anything you would like to say, sir?
No.
Why are you fooling around with cocaine? Let's get rid of that, okay?
Yeah, I had a day of the evening, I'm just
Well, I'm not, you don't apologize to me. I just worry about anybody who's getting involved with it.
Okay, I'm gonna do it right now.
Jail
Okay,
and deal with
okay,
Stefan.
okay, thank you so much.
All right. Have you been going to AA?
I've not done that part yet.
Why not?
One near me is in Monroe,
Hang
and
on.
I looked into
Wait,
it.
say again.
The only one near me, like the closest one to me is in Monroe.
Well, you live in Taylor.
Yeah.
They're all over the place.
Yeah, I mean,
What do you mean? You're trying to tell me you gotta drive 35 minutes to get to an AA meeting?
that's just what I saw online. I don't know if there's other ones that I didn't see.
That's the closest local law.
We're not gonna get along very well if you're gonna be this bad at complying with the orders.
Sorry about that.
Well, I mean, listen, nobody needs to apologize to me. You didn't hit me with your car when you were drunk. And I'm just telling you, you should apologize to yourself, because that just puts you in a bad light with me right now. You can't do that. I don't just order these things willy-nilly. And it's not just something I decide. I look at everything. You need to go to AA and NA. Look, you are what, 30?
Yeah.
You got bench warrants, and I get the fact that some of these are just traffic offenses. You got 1, 2, 3, 4, 5 bench warrants for failure to appear or take care of civil infractions. You had a attempt R&O in 16, attempt misdemeanor being a vehicle 200 or more, but less than 1,000 in 16. And that was, they made it an attempt, so that was a 6-month. Then you had a felony armed robbery in 17, drunk and disorderly in 21. You're fooling around with cocaine. I mean, come on, and you're driving drunk. Okay, so I just want to caution you here. I don't mean to sound like a tough guy. I'm not making suggestions when I tell you things, okay? All right? You have to do them. If you don't, we're going to have a problem. We don't want to have a problem. I'm placing you on probation for 15 months on both cases. I will take your drug case under 7411, as you agreed with the prosecutor. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol. No alcohol. You're not to purchase, possess, or consume alcohol or illegal controlled substances. No marijuana either. You're to submit to chemical testing, PBTs and ETGs. I'm going to make it weekly for 3 months. If you're clean, I'll make it bi-weekly for 2, then monthly, okay? But you have to test weekly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. In order that you go to AANA 3 times a week in person until you're in outpatient treatment, I'm going to order outpatient treatment on these. You have to provide proof that you're attending AA every time you meet with the probation officer. Okay? You have to do that. And then but once you get in outpatient, so if you don't procrastinate, like I sense you might be trying to do, you can get in outpatient next week. You only have to go to AA for 1 week. Do we understand what I'm also going to order that you attend the Victims Impact Panel, which is 1 night put on by Mothers Against Drunk Drivers. Do you understand that?
Yeah.
All these terms are going to run concurrent now. And so what I'm going to do, you were arrested, so he has 1 day credit coming, correct, counsel?
Yes, sir.
All right. 5 days jail credit, 1 served 4. 3 days court work program, $105 charge for that. 1 day of community service. I'm going to give you until June the 30th to complete that. So you can do 8 hours community service at any nonprofit organization of your choosing. Okay, I don't care where it is. Salvation Army, St. Vincent de Paul, a church, animal shelter, Habitat for Humanity. I could care less. But you have to do 3 days on the court work program. And I'm being more than fair with you here, okay?
Yes.
But you gotta comply with orders. All right. So I want you to understand I'm going to run all these terms concurrent. The day community service again by June 30. There's a $35 a day charge for the court work program, bringing your total there to $105. I'm also going to order on the impaired charge, and I'm going to put all the common fees on the impaired charge: 300 fines, 250 costs, 75 victims' rights fee, $50 justice assessment, 675 screening fees, 60 for 710. Probation fees are 300 for 1,010. Cost of recovery is 150 for 1,160. For attorney fees are 40 for 1,200, and you have court work program fees of 105. Your total's 1,305. There's a justice assessment fee on the drug charge. I'll only go 50 fines, 50 costs, 75 victims' rights fee, $50 justice assessment. So that will be 2.25. We're going to give them a review hearing date on that case. So that should be in late July, Heather, of 27. So you're 225 on that. You are, they will run concurrent, like I said. You're going to start going to AA, right?
Yes.
You're not going to ignore me again, right?
No.
Good. Then we'll get along just fine, you and me. Now, I'm going to ask you this. Don't lie to me. When did you last do cocaine?
That day.
Okay, good. So if we send you for a drug test tomorrow, I'll know that that was new use.
Yeah, I've been.
Okay, good enough. Good enough. I believe you. Good enough. I just was going to cover you in case you did. I was going to tell them don't have you test for a few days, but since you said no, we'll have you test. You owe 1,305 plus 225. That's 1,530. Can you pay all of that today?
No.
How much can you pay today?
$5.
Okay, you're going to take me serious, though, right?
Yes.
You're going to take me serious, right?
Yeah.
Also, you're going to clear all your warrants. Clear all of your warrants.
Can I interject real quick, Judge? I'm just getting a different total. Can we go over that real quick again?
Absolutely. You're probably right, Heather. You're going to clear all your warrants by July the 1st. Okay? So let me just see. 300, 250. That's 550, 675 with the crime victims' rights and justice assessment. 675, screening fee 60 for 735. Oh, probation fees are 300,035. Then I think I didn't say attorney fees. 11.
Okay, I did not get attorney fees. How much for
Yeah,
attorney
and I
fees?
wrote it down, $40. So it's 1345 or 1305, including that, right?
Well, cost recovery was 150, correct?
Correct.
I have 1330.
Geez, I think I'm low. 250, 75 victims' rights, $50 justice assessment. That's $675. The screening fee is $60 for $735. Probation fees are $300 for $1,035. Cost of recovery is $150 for $1,185. Court work program is $105, $1,290 plus. You're right. Thank you. $1,330. My apologies. I knew you'd be right and I'd be wrong. All right.
I'd
So
just
what do
like
you
to
have?
check.
How much can you pay per week then?
Per week,
Yes, or bi-weekly.
bi-weekly, I can do 100.
I'll make it 75. Your first payment isn't due until June the 1. Now listen, I tell everybody this, and then you're going to pay all your money at 100 bi-weekly on the B file after fines costs paid on the A file. Okay. Now I offer people this. I don't know why they don't take me up on it, but they don't. If you don't have the money, it's not a problem. Just call the court. We'll go on Zoom. I'll be glad to give you an extension. Okay? We'll go on Zoom or you can walk in here on it before the due date. I don't mind giving you an extension. Just you can't ignore me. Okay? You got me? All right.
I do have, one question about the court work program.
Okay.
That's only on the week, correct?
No, it's on Saturdays and Wednesdays.
Oh.
Now and then a Wednesday. We do that once a month on Wednesdays. And then every Saturday pretty much.
How long do I have to, like, could I kind of plan around a Saturday? I might not be working.
Talk to probation.
Okay.
Okay? They'll try to work with you. Okay? No more. You got to get off this stuff.
Yeah.
All right. Good luck. Thanks.
Thank you. Nice day.
You too. Bradley Lawrence Gaia. 26B12 150513A.
Good morning, Your Honor. Peter Bernard, P78413, MIDC counsel, for Mr. Guy.
All right. So he pled guilty to impaired. The OWI was dismissed.
Yes, Your Honor.
Who's got the phone? Whoever's got the phone, go take it out of the building, please. Sorry. All right. I'm sorry.
I've had a chance to go over the PSR with Mr. Guy. We don't have any additions, subtractions, or corrections. The only thing that we would ask the court to consider is, again, community service in place of court work program if the court so deems that part of the sentence.
How many times you got in trouble?
Speeding ticket.
You've never had a criminal charge before. So I'm not saying I necessarily agree with this. You were in the ditch, right?
Yes,
You were by yourself, right?
yes,
Nobody else was struck, right?
yes, correct.
Were you truthful on the screening?
Yes.
And this was a breathalyzer, correct?
Yes.
Do you want to say anything? You want to do all this stuff that they ordered you to, that they want you to do? Did you review this report? Pardon?
No, I do not.
You think you need it? I don't need it. According to the statute, there's really a presumption that that I'm not supposed to put everybody on probation. In other words, it's presumed that probation is not necessary on this type of offense. You get a 116 and a 113. Yes, you did drive into a ditch. Yes, you did admit to the police you were screwed up. Yes. You did test in category 1 on the alcohol use portion and the drug use portion. So I can't rationalize this in my mind, even though I might disagree with the law. That's not my province. $300 in fines, $350 in costs. That's $650. You have 75 victims' rights fee, $50 justice assessment, $775. Screening fees, $60 for $835. Cost of recovery is $50 for $985, $150 for $985, and I'm going to charge you $40 in attorney fees. Your total is $1,025. I'm also going to order that you serve 3 days jail credit, 1 serve 2. I'll let you serve those by way of community service. So 2 days of community service, 16 hours. You're gonna do that by. I'm going to give you until June the 30th to complete that. I'm not placing you on probation. I'm going to also order. I want you to do the victims impact panel too. That's one night. Put it on by Mothers Against Drunk Drivers. Anybody who ever drink should do that and driven. So I'm going to order that. So victims impact, 2 days community service by June the 30th. Fines cost $1,025, and you are all set. If you violate though, if you don't pay your fines, or if you don't do the victims impact panel, if you don't complete your community service, you could get 93 days with credit for any time served. Do you understand that?
Yes.
You have 21 days to appeal. You have 14 days to apply for a court appointed lawyer for purposes of appeal. Do you understand that? Stay out of here, will you?
Judge,
See you again. All right.
Judge, he also did have the distracted driving that was reduced down for 155 with that one too. That he pled to at the last hearing.
Correct. I'm sorry. You also owe 100. I'm going to charge you 150 on the distracted. Okay. They dismissed the open intox. So you owe 1175. Can you pay all that, or do you need some time? Okay. So you pay this now. You'll meet with probation now. I sincerely wish you well. Don't come back though. Okay.
Sure.
Have a great day. Thank you. Are we ready on Noah staff pool? Who had that one?
Mason,
Where's Mason? I want to get
he's in his office.
people against Nathaniel David Hayes, 5T 643636. John, find out what these lawyers have. Sadie, tell me what these lawyers have.
Mr. Zelnick's on tow, counselors on Gagne and Tillery and Gagne.
Tillery and Gagne? All right. Your name, sir? This is 25T 643636. I placed you on probation on November 6th. And we issued a show cause. Why didn't you show up for your review hearing on April 23?
There was a mistake. I accidentally read the wrong email. I had 3 different email threads from Miss Wiles.
Did you show up today late?
No, I was here before 9:30.
Okay. Raise your right hand. Some swear affirm under penalty of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
Yes, sir.
Since you were in court when I placed you on probation on November 6th, have you been arrested?
Yes, sir.
You have?
Yes, sir.
For what?
What
So you had another case after I put you on probation?
yes.
You can't dismiss this then. Where's that pending at? This is why I want them here. Where was that at?
Was why not?
Has that been disposed of yet?
Not yet. I still have a lot of work to do. Yeah.
You didn't get printed on that yet either, did you? They didn't print you either. All right.
I was in a Zoom meeting call with Ms. Wells for the 23rd. I misunderstood the email. I didn't know I was supposed to.
Don't worry about it. It has nothing to do with that. That's why I show cause you. But I called your case earlier and you didn't step forward. Let me, I'm not gonna be able to dismiss this. But let me think about it. Have a seat. I'm not gonna be able to dismiss it though. So you have a seat. I'll be with you in a second. Tyler Keith Tillery, 26G306839,
Wait,
A and B. All right. Good morning.
Judge Murray, nothing. Appearing on behalf of the defendant Tyler.
How old are you? You look like you're 15, huh?
He's all.
I know, he looks like he's gonna be a movie star someday. He'll be 32 when look like he's 32 when he's 50. How long were you adjourning this? 2 weeks?
2 weeks is fine, Judge. I think he's a candidate for sobriety for, this is the second offense for Mr. Tillery there.
What are you doing, young man?
So.
Where do you live? Brownstown?
Yes.
What's he doing with his life?
Judge, he's working. I got to know his family a little bit because this first one was in around this area, so I did represent him. He wanted to be a pilot, but that's been kind of thrown out of the wraps now. But he is working. He's a painter. He has a union job.
All
He
right.
doesn't work together.
What was his breath or blood result?
Quite too long.
I tell these guys when they come in here less than 21 on the first, like, you know, we had this first one 2 years ago, not here, but in Romulus, like you said. You start getting drunk driving when you're 18 years old, you're probably headed for a felony drunk driving at some point, and that's where you are. All you gotta do is get one more in the next 60 years. I'll adjourn it to May 21 at 8:30 if you're good then. The sooner we get them going, the better.
Judge, I do have a Zoom in federal court at 9 o'clock that day, so if I'm interrupted,
No, you want me to set another day?
can we do it later on?
Yeah, I'll do it at, how about 11?
That's fine.
We'll do it at 11, but I need to, I did not, you been going to AA?
Yes, Judge, he showed me a AA slip, since April 23rd, but
I gotta tell you though, I gotta have him on a SoberLink device. I'm sorry, defendant to be on SoberLink device by end of day. So you're gonna meet with probation. They're gonna explain to you how you do that. Do you understand that? You gotta get off of that. Okay, so we'll do it May 21 at 11. Be glad to take him. Seems like a nice kid, but you're ruining your life. What are you doing?
you want to make arrangements before that day, with somebody as far as Friday court or?
No, you can take the packet. Why don't you go over there unless you have to run out of here? We can do that. They'll give you a packet for him to review, and he can meet with the sobriety court probation officer now if he'd like, and they can at least explain the ins and outs of it, okay? And we'll see at 11 on the 21st, but I want you on a SoberLink device by the end of the day. Is his parents with him?
No, his parents are not here.
Where are they?
There.
They know about this?
Yes.
Good luck. Stay out of trouble, man. All right, good luck. Don't go anywhere. Yeah, I'm gonna take that. Julie Therese Gagne, 26G306741.
Hello, Joe Murray, Duncan, here now we have the defendant, Julie Gagne, goes to my right.
Good morning, ma'am. Your name?
Julie Gagne.
All right, so this is gonna be a plea to operating while impaired. They're going to dismiss the OWI, true?
Yes.
Is that what you want to do, ma'am? Is that what you want to do, is plead guilty to operating while impaired with the understanding that the OWI will be dismissed?
Yeah.
If you plead guilty to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service, court costs are all days, 4 points. License suspension or revocation in accordance with your record in your vehicle could be, or might have to be immobilized depending upon your record. Do you understand that? And did you sign, read, and understand the advice of rights?
Yeah.
If you plead guilty, you'll be giving up all those rights and we will not have a trial. Do you understand that? All right. Any questions before I go on? To the charge operating while visibly impaired, ma'am, how do you wish to plead? On March 20 of 26 at 11:07 p.m., were you operating a motor vehicle on Jefferson near Gibraltar, in Gibraltar?
Yes.
And prior to that, did you drink alcohol? And if so, what did you drink and how much?
Yes, I had 2 Jack and Cokes and a shot.
Shot of what?
I think it was peppermint shot.
Okay, was it a single shot?
Yes.
Was your ability to operate that motor vehicle impaired because of the alcohol consumption? And in what way?
I was told that I swerved, I was at a light, and when I turned, I was told I swerved.
Do you think you swerved?
Yeah, because I know because my car had to like autocorrect it.
Okay, do you think you swerved at least in part because of your alcohol consumption?
Yes,
Counsel, this says a 0.146 on the blood draw. Do you stipulate that was accurate for purposes of the plea?
Yes, Judge.
Are you on probation or parole, ma'am?
No.
Anybody force you to plead guilty?
No.
Ever been in trouble at all before?
No.
I'll accept the plea, dismiss the OWI. She had some case in 07, an ordinance violation, but it was dismissed. That's it. So I'll refer you.
Kind of record, Judge.
Right. So I'll refer you for a screening and assessment, okay? And you're gonna go down the home, you're gonna get your notice, and then you come back for sentence. You want to do this on the 21st? To Mr.
Yes, yes.
Yeah, I'll tell you what, we'll do this at 11 too, okay?
So you want her to go down and get a notice?
She's gonna go down and get a notice, then you're going over to probation where you'll fill out a questionnaire and be interviewed, okay? And then come back on May 21st at 11.
Thank you.
thank you.
Have a great day. And by the way, everybody, this is not my rule. If you guys would consider filling out those public satisfaction surveys, the Supreme Court wants us to do that. I'd appreciate it. Where is Brendan James Cho? 260-646-409. Is this kid gonna learn anything here if he dismisses this?
None of the victim is here, the parents.
Where's the victim at?
She's seated in the bank.
Come on up here.
There's two cases, Your Honor, so if there's a global resolution.
Oh.
Vote.
Okay.
Oddly enough, since we were here yesterday, his grandmother just passed away, so the family's got to go. And it's been just a rough week. Ma'am, would you step forward? You step back. Edward Zelenak, the defendant, is present.
Good morning, ma'am.
Morning,
Your name?
Jill Frederick.
Okay, why don't you go right over there, if you would, to that is a microphone, believe it or not. And I have Brendan James Trout, 26BT 646-409 and 26B 149414. Your name?
Brandon James.
All right, and his parents are with him.
Yes, they are.
And the victim is not seeking restitution, it says on 414. Are you the victim on the Brownstown case, ma'am, or the Trenton case?
Trenton case, brother.
All right, are you seeking restitution of any kind?
Just for the records to be completed.
It's been arranged already.
All right, I need to put it on record though. Call him Mr. Bologna. So he's going to plead to the turfing charge under height on the Brownstown case. And that is, if you plead guilty here, these are the possible penalties: up to 500 fines, 90 days jail, costs, or all those. This would be taken under HIDA. And I believe, and I haven't had a turfing case in years, I think if there's a straight up plea that you'd lose your license.
No, this shouldn't go anywhere.
Well, I know it won't under HIDA, but I'm just saying if there was a straight up plea, you would lose your license. Do you understand that?
Yes, sir.
So if you don't comply with probation, the conviction's going to be entered and you're going to lose your license. Do you understand that?
That's right.
Did he go get Mr. Bologna? 249. So if you plead to that one, the prosecutor's also going to move to dismiss the Trenton case of turping. Do you understand that?
Yes, sir.
Did you sign, read, and understand an advice or rights form here today?
You signed it yesterday. You signed the advice part.
I still need to sign one today. You're presumed innocent. They have to prove you guilty beyond a reasonable.
I'll give it here to sign what you're talking.
Okay. Did somebody get a hold of Mr.
Just
Wood?
call them.
Okay. Miss Frederick, I'm sorry. You live on, just tell me the street. I'm sorry, which one?
Third,
Third. Okay. Mr. Bologna, your name?
Anthony Bologna, Your Honor.
I want to make sure everything's covered here. Is there some kind of I understand what you're doing. He's pleading on the Brownstown case, victim not seeking restitution. It's going to be under HIDA. Based on that, this other case, the Trenton case, is going to be dismissed. I just want to make sure that the restitution is going to be taken care of.
My understanding is being taken care of. It was presented with a company that's providing services.
But if the case is dismissed, I lose jurisdiction is the problem.
I understand Your Honor.
Well, we can come back. They can charge him again, Judge, and there'd be hell to pay that.
Well, no, not if it's part of another plea agreement.
Why don't
Did you get a quote?
I did, yes.
How much is the quote for?
676.
I think there's a work order too that you might have already, right?
Wait a second. Are the parents gonna pay the $676?
Yes, they are. They've already paid, have you paid the company already?
Your Honor,
What's your name, sir?
Chris Cove,
Okay,
that is that. The company that I reached out to actually takes care of her loan as well for sterilizing and repair. He is just trying to fit in the schedule.
have you paid them yet?
I offered to pay a deposit. He said he wanted to wait until the work was done because it could be in time and materials, but that's 676 was his maximum.
Max,
Yes.
but see, I can't dismiss this, guys, without that being taken care of. Now, if he wants to cut a check to her today, $676, then I can feel comfortable dismissing.
I have no problem. I have no problem with it.
You're gonna pay the $676 today? Can you do that? Because I can't dismiss a case and still have restitution hanging over, and I don't think it's,
So,
you're good with that?
Yeah.
And what's your name, ma'am?
Michelle Cove.
I appreciate you guys coming a lot more. Your son and I are gonna have a conversation. So that's what'll happen. You have a checkbook here?
I do.
So you can write her the check, write out to herself, and then we're gonna cover this. Is that acceptable to everybody, Mr. Zelnick?
Works for me, Judge.
Is that acceptable, Mr. Bologna? Is
Absolutely.
that acceptable to you, ma'am? All right, that's what we'll do. So you can write that check to her. I will dismiss this as soon as you hand her the check. I'm gonna take the plea on the other turfing. And have you signed that advice of rights now, young man?
Just did it.
If you plead guilty, you'll be giving up all those rights on that advice of rights, and we're not gonna have a trial. Do you understand that?
yes, sir.
You understand everything that's going on?
Yes, sir.
You seem like a nice kid. Why in the world would you be doing this? We're gonna have a conversation. To the charge of turfing, how do you plead?
Guilty.
On the Brownstown case, March 29, 26, were you at 19256 Dawnshire Drive in Brownstown? What did you do?
Because I was very upset.
Upset with what?
But we were bad breakup and.
With who? With who?
Her daughter.
So it's collateral damage.
Well, wait a minute. 19256 Dawnshire, your daughter doesn't live there, or does she?
No, it's another friend.
That's all her friend.
Well, wait a minute.
That's,
I'm just taking the plea on the Brownstown case. Okay? So why did you drive over the lawn at 19256 Dawnshire? Who did you know that lived there?
a friend that's dating your daughter.
So you intentionally drove over the lawn.
Yes, sir.
All right. Are you on probation or parole?
No, sir.
Anybody forced you to plead guilty?
No, sir.
But you guys broke up before they started dating, right?
My understanding, yes.
Well, no, I'm asking you. You and her daughter broke up before your best friend started dating her, right?
How about if I ask the question, your best friend you found out started dating
Yes,
her
sir.
and you got upset and you made marks on everybody.
But were you broken up with her daughter at that time?
Yes, sir.
You gotta be more mature than that.
Yes, sir. I
right?
understand that.
All right. Anybody force you to plead guilty?
No,
Are
sir.
are you on probation or parole?
Sir.
I'll accept the plea. Ms. Frederick, I want to listen to what you have to say. Anything? I know that you're, you've got the check?
They're doing it right.
Okay,
Sorry.
go ahead and write that check and then we'll talk. Do you want to tell me anything, ma'am?
Only if you need clarification on anything.
I'll be happy to listen to anything you have to say.
I'm good, thank you.
Okay. What are you doing with your life right now?
The operator.
The what?
Operator G.
Okay.
324.
Good, good. And you are going to be 20 in December?
Yes, sir.
I don't need a pre-sentence report, Mr. Zelmer.
No, we're fine. He has done well, I presume, because he went straight into the union. He's got a pension and healthcare and a better suit than most lawyers here have today.
Better than one I brought. You know, I didn't even bring my coat in today. I put it on the couch. Anyway,
Nothing else to add. Your Honor, it speaks for itself. These are sad incidents for affairs of the heart that Ben, whose brains don't form as quickly as
I know.
women and crazy things.
I know. Where'd you go to high school?
Friend.
And so you're gonna stay out of here, right?
Yes, sir.
Did you ever have a conversation with them, man? With his parents after this?
They have reached out to me the day afterwards,
To say what?
to apologize and ask if they could make things better.
That's what I would have expected parents to do. And I want to commend you guys for doing that, because a lot of parents would not have done. A lot of parents would have looked the other way. So it means a lot to me, frankly, that the parents came with you, Mr. Toth. So that's going to help you. You don't want to do this to your family.
No, I did not.
I feel like making you go read a poem.
To read Shakespeare, Judge.
No,
Doesn't
no, no. I want you to Google this when you get home tonight. You don't have to do it tonight. Talk to your mom and dad about it.
Sure.
Just Google your name poem. Do that. Now, it's a little gender related, but you can look at that with your mother too. You follow me? It's your name. Read that poem. Okay? All right. I'm not going to be that tough on him. I mean, what he did was silly, but you know what? We've all done silly things. I did silly things. We all did silly things. But I want you to understand something. I do not condone this. You got to use your brains. This kind of thing affects your future. You follow me?
Yes, sir. I completely agree.
You don't want to affect your future. So I'm taking the plea under HIDA, Mr. Zelnick. I think I already asked you, but if you have something else, I'll listen to you.
Yeah.
Do you have anything else, young man?
No, sir.
All right, let me just write this up. How do you feel about this? Because you are a victim. And I want to make sure that you're satisfied too. I don't want to poo-hoo this. I don't think there's anything to poo-hoo. By the same token, kids make mistakes. And to a 19, 20-year-old kid to find out his best friend started dating his girlfriend could have been handled like 10,000% better. But what are you asking me to do? Anything?
I'm good, thank you.
All right. I have to place you on probation, so I'm going to for 6 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as direct. Now, I'm not going to know if you do this, but see, your parents have shown a real interest in you. I think that's phenomenal. They did what I would have done. They did exactly what I would have done, and they're here. And that means a lot. So I want you to serve 1 day of community service by June the 30th, and I want you to be on our court work program for 1 day, and that's going to cost you $35. Parents are going to make sure you read the poem, your name. See, my father was buried 40 years ago today, so I'm a little more sentimental than usual. So, I actually went back and read that. 100 fines, 100 costs. 75 victim strikes, $50 justice. 120 in probation fees, 35 in attorney fees.
No, I'll take.
I'm sorry, 35.
I'll take the.
No. I'm sorry, 35 in court work program fees. That's $480. I want him to pay this, not you, folks. So if you need time, I don't have a problem. And they're going to make sure that you read that. I don't need you to tell probation or prove anything to probation. They're going to make sure you read that poem. Can you pay this today, or do you need time?
Bill Trades can take care of it.
And you've received your payment, right, ma'am? The 626?
676.
676, I'm sorry. And you're satisfied?
Yes.
So I'm dismissing 260-646-409. Prosecutor indicated on the Brownstown case, victim was not seeking restitution. We're going to give you a review hearing date. You don't want this on your record. Give me a date if you would, Heather.
Okay, Judge, that will be November, well, let's see. About November 4th.
November 4th at 8:30. You don't need to show up, Mr. Zelnick, unless he hasn't complied. Folks, thank you very much for coming. I appreciate it. I don't want to keep people waiting. I need a 5-minute recess. Thank you. Stay seated, please.
Okay. Got something. You know, you got something for me. Just trust. Gotta do it. It's one of those two things. I could just be gonna say, I don't know, I've never started with that. Oh, is that needs to be a bunch? Oh, you got the crazy. Yeah. I'm asking. You can get you to last day. That's it. We submitted those like that Friday. She's talking about that. So, well, he wants to see if evidence is started.
Good morning, Mr. Boker.
Again? I said I'll be on parole upon release from prison, but not at the moment, no.
Got it. All right. Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, I am.
and also of your own free will because you believe that you're guilty of this offense?
Yes.
All right. On the date of August 21st, 2024, at the location of 2723 Oak Valley Drive, Pittsfield Township, Washtenaw County, State of Michigan, what'd you do that makes you think that you're guilty?
I obtained credit cards.
Okay, you obtained credit cards, but you didn't have the authority to use those credit cards?
No, sir.
All right. And guessing from the restitution, you went into Meyer and used those credit cards?
Yes, sir.
And then you received some type of goods or products from Myers by using those credit cards. Is that correct?
Yes, sir.
All right. So I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, that if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor.
I'm aware of none. Have I complied with the court?
People are, that's fine.
Yeah, Judge, thank you. Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be.
At 12.
You're going to be able to get to here by then. May 27, 2026, 12 noon.
What day?
4 p.m. Pardon?
What day is sentencing?
May 27th.
Okay.
Okay, my probation officer will be in touch with you. Okay? All right, thank you. Bond continued. Thank you. Court calls case in People versus Winona Harvey.
Ashley Feltus for the people. Your Honor, Joy Gaines, senior assistant. Representative Harvey.
Harvey, would you state your name?
Yes,
Would you state your name, please?
Winona Harvey.
Go ahead, Ms. Gantz.
I have received the report and at this time would stipulate to the report.
Where she is still incompetent, but restorable.
That is correct, Your Honor.
Do I have any other additional information?
No, Your Honor, we also stipulate to that report's speech and ask you if I make that finding.
All right. Well, we'll make the finding that the defendant is incompetent, but restorable. I'll set a review date for August 6, 2026, 9 a.m. Bond will continue.
Thank you.
Well, we'll continue, Judge.
Say again?
What's gonna continue? What's
Is it
going on?
continued?
What's going on?
What's going on?
Yeah.
Okay, I made a finding based upon a report we have that they're trying to restore you to competency. So as soon as I get that order, I'll sign it, and then we'll see you in August.
Okay.
Okay? Thank you.
All right.
Can you make sure there's somebody prepare an order for the court on that finding? Court does call the case, People versus Anthony Reeves.
Morning, Your Honor, Raymond Cook with People.
Good morning, I'm Rob Chico on behalf of Mr. Reeves. Anthony, would you state your name for the record?
Anthony Lamar Reeves.
Thank you, sir.
Judge, I had a phone conversation with him this morning. My visit kind of got screwed up, but that being, as he set this for our exam.
Your discovery is complete.
Sure.
And what facility are you in, sir?
In Lapeer to Thumb.
He's in Lapeer. Because we're on the 19th now. I'd have to set it either for the 26th or June 2nd.
Judge, he'd like the earliest possible date.
Earliest possible, okay. I'll have to go a little further out so we can get it transported down. People have their witnesses available on the 26th.
Do our best, Your Honor.
Preliminary examination in person will be set May 26, 2026, 9 a.m. before me.
Anthony, I'll come out and see you, okay?
All right. Thank you, sir. Court calls the case, People versus Toronto Rogers.
Morning, Your Honor, Raymond Cook for the People.
Good morning, Your Honor. Assistant Public Defender Chelsea Virgil with and on behalf of Torino Rogers. Mr. Rogers, please state your name.
Torino's Molly Rogers.
Thank you, sir.
Your Honor, I'm asking to adjourn this probable cause conference. There's an update on the plea discussion I need to share with my client and has unfortunately not approved me as a visitor.
They've not.
No, I applied though.
Okay. Probable cause conference, May 28th, 2026, 9 a.m. I'll continue.
Thank you, Your Honor.
Thank you. Court calls case, People versus Rajad. Is it Asha Parsik?
Morning, Your Honor, Raymond Cook for the People.
I'm sure that's correct, Judge.
That's all I could.
Ready, Judge Torshell Fuster, Assistant Public Defender on behalf of my client, who should be on Zoom. Please state your name for the record, sir.
Riyad Azrabazik.
Exactly what I said.
Yes, sir.
He did good. He did great. Yeah.
Thank you. Thank you for the compliment. I blew it. I know it. All right. What are we doing?
To my knowledge, all discovery is complete. We're asking for an exam date, please, Judge.
People have their witnesses available the 19th.
Do our best, Your Honor.
Preliminary examination in person will be set May 19th, 2026, 9 a.m. before Judge Garwood. Bond will continue. Thank you. That's an in-person hearing, sir.
Thank you. Thank you, Your Honor.
Court calls the case of the People versus Dion Baldwin.
Morning, Your Honor, Raymond Cook for the People.
Good morning, Your Honor. Joy. Thank you. Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Baldwin.
Your name, sir?
Dion Tar Baldwin.
All right.
This matter was adjourned last time for some additional time from us, for our office and Mr. Baldwin to go over the, and to consider the recommendations in the evaluation, which we're recommending that Mr. Baldwin be found not competent but restorable.
What's the date of your report?
Your Honor, we were in court 2 weeks ago, so that I will grab my laptop, so it's set.
Right, and then we had to adjourn it out, but I got it. From a February date?
That is correct.
Okay. Yes, and I reviewed that. So you're stipulating to that report?
That is correct, Your Honor.
People stipulating?
Yes, Your Honor.
Based upon a review of that report, the court would find the defendant at this time is incompetent to stand trial but restorable. And I've signed an order to that effect. I will set a review hearing in this matter for August 6, 2026, 9 a.m. Bond will continue. Thank you.
One second, I'm just gonna wait for them to fulfill.
Court calls the case People versus Derek Hunt. Sorry. AG.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Morning.
Assistant Public Defender Chelsea Vergios with and on behalf of Derek Hunt, who appears via Zoom. Mr. Hunt, state your name.
Derek Hunt. All right. Well,
A month if possible. He has made a payment and he's ready to make further payments. My understanding is there's a change in the total amount owed. So I think we're close to, moving on in this case, just asking for a little more time.
all right. Any objection from the people?
I'm not sure why do we keep delaying it here instead of just waiving up and entering the delay plea then? I think he's in a position where we can move forward with that if you'd like.
Okay. I did not realize that. I apologize. Is it possible to ask Mr. Hunt on the record if you'd like to waive?
Well, you haven't had the conversation with him, right?
I have discussed, Mr. Hunt, do you remember me telling you about your right to a preliminary exam and how any offer in this case requires a waiver of that exam?
Yeah, I briefly, that's our first conversation, yeah.
If you'd like, you can waive today, move up to circuit court, and we can seek a resolution there based on the offer I previously discussed with you.
I would like if we can still just try to adjourn it for at least one more month. I have majority of the money, so I'm just making sure I have all the funds.
Okay, that's fine if he needs one more adjournment. I'm looking at a balance of just over 31,000 right now, just so we're aware. But yeah, that's fine, Judge. If
Just over 31. All right.
Yeah.
Probable cause conference will be adjourned June 4th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Thank you. And Madam Attorney General, you see that figure that you gave, did a $5,000 payment get attributed to the account? Can you see that?
I see an over $10,000 payment that was attributed to the.
Okay. So that must include this because it closed out over there. So it probably got over and applied. I just wanted to make sure it got applied, his bond.
I don't think that the bond amount is included. I think that was two separate payments. If I'm understanding based on a previous discussion, the bond amount hasn't been yet applied to what you're saying has been paid.
I
So
see a payment. Yeah, I don't see a recent bond payment. I don't see a recent payment of $5,000. No.
It would have been February.
it would have been in February.
No, I do not see that. So that's still somewhere.
Oh, great. Okay. We'll move on and I'll see him in a month and we'll check on that to make sure that 15 sent over that to the court.
Thank you, Judge.
Thanks, Your Honor.
Thank you. Court calls the case, People versus Timothy Cunningham.
Good morning, Your Honor. Good morning to your staff. May it please court move to group P86437 on behalf of Mr. Cottingham, who's approaching to my right. Sir, could you state your name for the record?
Timothy Cottingham.
Thank you.
Date and time set for a probable cause conference, Your Honor. We are asking that this matter be set for preliminary exam. I am requesting.
All discovery is complete.
Yes, Your Honor. I am requesting a date of June 2nd. We do have trials on the 18th, pushing into 19th
You
as well as.
don't get to request your date. What's the reason?
We have trials on, I believe it's going to push into the 19th, and then we have a federal trial starting.
Whom?
Myself, Attorney Martell, and Attorney Nasser.
Your Honor.
Yes.
We received about 200 pages of medical records from the victim in this case. I had to hand redact those. I finished that yesterday afternoon. So I'm not sure if those have been, I don't know if that's happened yet, but they will happen very soon. But it did take a little bit of time for last week. And I haven't been able to communicate about that with Mr. Martell or Mr. Nasser yet. So I don't know if they're aware of it, but they are coming. I apologize. I couldn't get them done before yesterday.
So you don't have all of the discovery?
I have medical records I have defense copy of 155 pages. So I'm not sure
at those
full medical records.
I'm not aware of how many other records would have gotten over. I got records and I redacted them yesterday. I'm not sure.
So you redacted them yesterday. Those medical records you're looking at came before yesterday?
Your Honor, the version I have is unredacted. I'm just not sure if this is the exact same version that the people have.
So we're not sure about what discoveries there and everything. So what I'm going to do is I'm going to put this out 1 week. So that you can look at those. It won't affect the date you're necessarily asking for prelim, but I want to make sure that all discovery is complete on it so that you have an opportunity to have that and your client can look at it or at least talk with them about it. Of course, probable cause conference, I will 1 week to 14th, May 14th, 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Have a good day.
Court calls case, People versus Aaron Brandon.
However, on behalf of Mr. Brandon, who is approaching the podium and will be standing to my right. Mr. Brandon, once you get up here, please state your name for the record.
Aaron Brandon.
Thank you. Thank you, Your Honor. The court should be in receipt of my adjournment form. We are requesting for an adjournment at this time.
Where yesterday I discovered another warrant request from Mr. Brady from January, so it's not a bot violation, it's even gonna rain till April, but I did authorize 4 new charges: assault with dangerous weapon, unlawful driving with motor vehicle, firearm possession by a felon, and domestic violence against a different victim. So that should be coming in hopefully soon.
All right, I've got a couple other cases, so you may have to wait for me in the hallway.
So probable cause conference, I'll adjourn this out. Hopefully, if you authorize it, hopefully we can get it done, get it set, so they'll be together at least. So I'll adjourn this out to May 28th.
Your Honor, I'm not available that week.
Good.
Your Honor, I'm getting married that weekend. If I could just have you.
What?
Or yeah, I tricked some poor woman into it. So, but I'm not available.
Married that weekend?
Yeah. If I could see the.
So I should ask her if I should set this.
I mean, she will be the real power after this.
And I want you there. No.
Like a week either before or after. Thank you, Judge.
You want me to set it for the 21st? I just don't know that we'll catch it in 2 weeks.
Sheriff's office today and hopefully get that sort two done so that it'll hopefully be around 2.
Are you available the 21st or you got stuff you got to do?
I mean, I'm busy, but for you, Judge, I'll make some time.
Is that how that works? Don't blame me when you don't get something done. All right. May 21st, 2026, 9 a.m.
Judge.
Bond will continue. All right. And again, congratulations, Judge. Court calls the case of the People versus Seaper Kent.
Good morning, Your Honor. On behalf of
Ready, Judge. Foreshow Feaster, Assistant Public Defender on behalf of Mr. Kent, who is approaching the podium. When you arrive, please state your name for the record, sir.
Seaper Kent.
All right. Thank you, Judge. We did meet with Mr. Kent, and I have had conversation with Ms. Willingbrae. We have began receiving all the discovery. I believe we need an adjournment to receive the rest of it to find out how we're going to proceed, Your Honor.
I did just provide Whiting with a sign of protective order, so just wait for the signature on that. Some additional discovery that did. Wow.
All right. I have signed the protective order.
Yes.
All right. And so how much time would you be looking at?
Not knowing how long it will take, I'd say maybe 3 weeks, just to make sure we have it.
Probable cause conference will then be adjourned to May 28th. You're not getting married, Feaster.
Not again, Judge.
Oh, okay, okay. Oh, that's right. Never mind. May 28th, 2026, 9 a.m. Bond on this matter will continue.
Thank you. We'll come see you again, okay?
Court does call the case, People versus Lawrence Buckner.
And on behalf of the people, Your Honor.
Your Honor, my client just stepped out in the hall. I'm just having
Yeah.
Chris Cover, I'll be talking about Mr. Buckner.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Buckner, who approaches.
Your name?
Say your name.
Lawrence of the family of Buckner.
Your approach.
You may. I understood, sir.
I heard exactly what you said. So you told me to ask my counsel if I have any questions in regards to being justified at any location.
Stop there.
Yes, he asked me. I'm just showing y'all this is.
Just say you understand.
Yes, yes.
Right. Thank you.
All right.
Okay. All right. What else?
That's it.
Oh, I didn't know if I was dismissed yet. Thank you.
You will let him know I could have handled that very differently.
Oh, I'll drive.
Oh, okay, thank you. All right, that's it. No more Mr. Nice Guy. Sorry for everybody else. Court calls the case, People versus Jason Haydu Banks.
Good morning, Your Honor. Mark Krieger on behalf of Mr. Haydu Banks. May I just have 1 minute with 30 seconds with him?
15.
Okay. Okay. I'm prepared. I hope that.
Okay.
I think it was maybe 20.
Yeah, it's 12. You're good. Okay. All right. Your name, sir?
Jason Haydu Banks.
All right. What are we doing?
Your Honor, I have not received any discovery yet, so I'd ask that we have a short adjournment of the probable cause conference so that I can review the discovery and make an informed decision with my client on whether to proceed to preliminary exam.
I gave Mr. Krieger our email address and his certificates, so.
Probable cause conference will be adjourned then to May 21st.
Can I just check my calendar?
Certainly.
That's fine. And what time, Your Honor?
I'll set it at 9, but you'll get a
notice, right?
Regarding that.
Okay.
All right. Bond will continue. Thank you.
Okay, so.
Court calls the cases of the people versus Robert Laster.
Good morning, Judge Hall. On behalf of Mr. Laster in case ending in 1326.
Public Defender Chelsea Virgil is with and on behalf of Robert Laster on the other two cases.
And Laster, can you state your name, please?
Robert Laster, Your Honor.
Thank you, sir.
Thank you.
You're looking for an adjournment?
Yes, Judge.
So also, Mr. Diaz?
Yes, Your Honor, just try and keep all the cases together.
All right. I'll adjourn these matters to May 21st, 2026, 9 a.m. Thank you. Court calls the case People versus Angel Martel.
Please let them have the
Morning, Your Honor. Alex Warren, Green on behalf of Mr. Martel. State your name. Angel Martel.
Thank you.
Your Honor, I have prepared an order to undergo a competency examination. I would ask the court to order a competency evaluation.
So you want a forensic evaluation?
Yes, Your Honor.
Forensic evaluation will be ordered. I'll set a competency hearing date for August 6, 2026, 9 a.m. You prepared that order?
I have, Your Honor.
All right. Bond will continue in this matter. All right. Thank you, sir. Court does call the case of the People versus Nicholas Strunk.
Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Strunk. On Zoom. There he is.
Mr. Strunk, unmute, state your name.
Nicholas Strunk.
Thank you.
Your Honor, we're asking to move forward to exam. Discovery is complete.
Will people have their witnesses available the 19th? Preliminary examination in person, May 19th, 2026, 9 a.m. before Judge, before me. Bond continue. Thank you.
Thank you.
Court calls the case of the People versus, really? Jada Olive.
People.
Your Honor, as to the person that's getting married, the attorney, after that marriage date, he'll be on informal probation.
Yes, absolutely.
She was in the middle.
Sorry, Mr. Allen.
And good morning, Your Honor. Robert Elman on behalf of Ms. Olive in case ending in 131.
Your Honor, Bill Clovis, P38434 on behalf of the case of 25-16344. I'm sorry, 26F10173FY.
All right. Your name?
Jada.
Thank you. What are we doing?
We're going to be waiving preliminary examination.
He's waiving on both.
Yes, Your Honor, you should have a signed waiver on the file on my.
So all of you, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on all three counts.
Your Honor, we would stand mute and waive any formal reading.
Stand mute.
Defendant having waived formal reading, standing mute to all charges, court will enter not guilty plea as to all counts. Pretrial will be set for
May 18th at 1:30 with Judge Hamoud.
May 18th, 2026, 1:30, Judge Hamoud.
I'm sorry, who was the judge assigned on it?
Hamoud.
Thank you.
Bond will continue.
Thank you, Your Honor. Always nice to see you, Judge.
Good seeing you, sir. I mean, I can feel it. Good deep breath. Court calls the case, People versus Raffinian Brooks.
Brandon, don't give me your.
Morning, I'm Rob Chico on behalf of Judge standing in for Mark Shakur regarding Raffini and Brooks.
Bless you. Wow. Don't do that again. That scared me.
Brooks?
Raffini and Brooks? You're not here.
Judge, Ms. Kreischer was asking for an adjournment. She was just appointed. I don't know if he knows about this hearing. You being the considerate judge you are, and very compassionate, I would ask for a 1-week adjournment.
For you, I would be that way. However, it's Kreischer's case. Bench warrant. 10,000 cash surety.
What was that, 10,000?
Yes, cash surety that will issue immediately. Thank you.
Thank you, Your Honor. My opinion hasn't changed.
Wow. Court calls the case, People versus Antonio Williams.
Morning, Your Honor, Raymond for the people.
Sign this, right? They need to sign this.
I need, no,
they, okay.
no, they need to sign the image.
That's
that. Yep.
Joy Gaines, Senior Assistant Public Defender, representing Mr. Williams.
Sir, can you state your name, please?
William.
Thank you.
Now, we've received a competency that updated report, and at this time, the report is stating that Mr. Williams is still not competent, but is still restorable, and we stipulate to that finding.
Here are the people so stipulate as well.
All right, the court will continue the finding that the defendant is incompetent but restorable. I'll set a review hearing in this matter for August 6, 2026, 9 a.m. Bond will continue. Thank you.
Thank you.
Court calls the case of the People versus Jonathan Sims. Who's that?
Brandon.
Okay.
Good morning, I'm Rob.
Thought I'd ask.
Anthony Jonathan Sims. Judge, we have the discovery. We're asking for a preliminary exam.
Your name, sir?
Jonathan Sims.
Thank you. You have all discovery?
Yes, Your Honor.
All right. People have their witnesses available the 19th? All right. Preliminary examination, May 19th, 2026, 9 a.m. before Judge Garwood.
Co-defendant in custody.
He has a co-defendant in custody. Who's on that?
Yeah.
Okay, before you said that. Ms. Yagi is, what's it?
Hickenbottom.
Hickenbottom. It's a co-defendant. Are you also looking to set exam on that one?
Yes.
Okay, then we'll set it when it comes out. All right. Bond will continue on that one.
Thank you.
Okay,
well, I should meet
Court calls the case, People versus Joshua Hillsborough. Berg.
However, on behalf of Mr. Hillsberg, who is approaching the podium and standing to my right. Your name for the record?
Joshua Hillsberg.
Thank you.
Yep. Today's the date and time set for probable cause conference. We are asking that the matter be set for a preliminary exam.
Both matters?
Yes, Judge, both.
All right. All discovery is complete?
To my knowledge.
And will the people have their witnesses available the 19th? All right. Preliminary examination, May 19th, 2026, 9 AM before me. Thank you, Judge. Thank you. Bond will continue.
Okay.
Court does call the case People versus Diamond White.
Morning, Robert G. Thorne, Diamond White. State your name. Diamond White. Judge, we have the discovery. We're looking to set exam dates.
People have their witnesses available the 19th.
Mr. Honor.
Preliminary examination, May 19th, 2026, 9 AM before Judge Garwood.
Thank you, Your Honor. We'll go, okay? Look at these all.
Bond will continue. Thank you. Court does call the case People versus Aaliyah Benton.
Horrible for everything.
Good morning, Your Honor. James Fifelski on behalf of Ms. Benton, who is coming out soon. Please state your name for the judge.
Aaliyah Benson.
All right. Your Honor, this is a new file. I'm asking the court to adjourn for discovery.
Probable cause conference will be adjourned to May 21st, 2026, 9 AM. Bond continue. Thank you. Oh, right.
Just is present. Today, I'm requesting that the defendant sign some documents as it relates to the current care for her children. So I'm just requesting that the defense counsel review those with her and see if she will sign them, or I will ask them. Or intervene, but I hope that would be necessary.
Your Honor, I do have the documents. I don't have a problem discussing those with her. All right. And so I do plan to do that. I did fail to request if I could very briefly address bond. 30 seconds tops.
Go ahead.
Your Honor, she has a $250,000 bond at this point. Her only prior conviction, I believe, is an impaired. She's on bond on a violation of probation with Judge Barr. 5 kids she does need to financially provide for who are under the care of CPS, and there is a family safety plan. I'm just asking that you grant her house arrest so that she can at least work, provide for her children while these cases are pending.
Respond.
So I'm going to check bond at this time. This case involves the shooting in the butt of a 4-year-old, the defendant's 4-year-old by her boyfriend, I believe, who has not been found. The defendant did transport Skylar to the hospital and then proceeded to lie to police about what happened to him, and then tried to leave the hospital without speaking. So I have concerns that he has a flight risk and danger. Given that we don't currently know the whereabouts of who will be her co-defendant, I have additional concerns that she will try to get in touch with him.
Anything else?
GPS tether would help keep track, for Your Honor.
Motion for bond reductions denied. Bond will continue.
All right, thank you. I'll be back for shortly. Going on. Thanks.
Okay. Sorry. Court calls case People versus Kevin Davis.
And James Fifelski on behalf of Mr. Davis, who is approaching. Name, please.
My name is Kevin Ryan Davis.
Your Honor, just retained on this file, still waiting mostly the video discovery, asking for an adjournment for that to take place.
Probable cause conference will be adjourned May 28th.
Judge, I'm actually out of town that day.
What? What's his name's got a wedding. Everybody's going to be here.
Well, I have no weddings, but family coming into town and
like
family activity. I do. Yeah, my brother, older brother, he teaches me a lot of good things that.
Yeah, he's not been doing it. Will the 21st work?
Will the first thing in the morning. I know because my other client's in custody. I have a 10 o'clock mediation for the whole day. But if Out of custody goes later. That doesn't work.
Okay. At what point on my face did it look like I cared? I'm just picking a date. We'll figure out how to make it work. You want the 21st, but you don't want the 28th.
I can't do the 28th.
Jeez, so Pete, June 4th.
That's great. Thanks so much.
Yes.
Very kind of you.
No, it really wasn't. I just got exasperated. June 4th, 2026, 9 a.m. Bond continued.
Thank you, Judge. Have a good day.
You do the same. Thank you. Court calls the case, People versus Wesley Brand.
And adults for the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Brand. Your Honor, we are requesting it in order to get some coverage.
Probable cause conference will be adjourned May 21st, 2026, 9 a.m. All right, thank you. Bond continued. Court calls the case, People versus Jennifer Baker.
For the people.
Good morning, Judge.
Morning. You're Miss Baker?
Yes, Jennifer Lynn Baker.
All right, thank you.
Public Defender Jay Bellinger on behalf of Ms. Baker, Your Honor.
All right, what do we do?
Your Honor, we are potentially going to be setting this. I just need a little time to talk to my client about the repercussions of potentially doing that.
All right. Probable cause conference, May 28th, 2026, 9 a.m. Bond continued. Thank you, Ms. Baker.
Thank you, Your Honor.
Thank you. Have a good day.
Thank you. Court calls the case of People versus Michael Birch.
And Stephanie Can on behalf of Mr. Birch. Mr. Birch, could you please state your name for the record?
Michael Birch. Thank you. Really?
Yes, Your Honors. I mean, Your Honor, we're just asking for a shlick adjournment of this case, please, for investigation purposes.
May 21st, 2029 a.m. Bond continued. Thank you.
Okay.
Court calls case People versus Shelby Barber.
Stephanie Can on behalf of Mr. Barber. Mr. Barber, could you please state your name for the record?
Shelby Barber.
Your Honor, we are adjourning this. It's my understanding that new cases potential on this. Is that correct?
That's correct. You charged Kevin Robson, I'm not following the Judge wanted to study from this year for account of old substance possession. I will follow up on how that has just one to pray.
All right.
So, Your Honor, we're just asking for an adjournment to handle those together if possible.
What I'll do is I will adjourn this to June 4th, 2026, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Thank you. Court calls the case People versus Contrell Cooper.
Assistant Public Defender Jay Bellinger on behalf of Mr. Cooper, who approaches.
I didn't check the door, were they? Okay. 3 cases.
That's correct. Go ahead and state your name for the record, okay? Contrell Cooper.
Thank you.
Your Honor, we are just at this time looking to set all of these matters.
For preliminary examination.
Yes.
All discoveries complete.
Best of my knowledge, Your Honor.
All right. The people have their witnesses available on these 3 matters on the 19th. Preliminary examination will be set May 19th, 2026, 9 a.m. before me.
Waiting to hear back from that. Before you?
Yes.
Thank you.
Thank you.
Yeah.
Court calls case People versus Manuel Barnhouse.
Here, Your Honor.
Seriously, she was just here. She's like a squirrel. Find her. Where'd she go?
Oh, which one?
Burned house.
Oh, thank you.
Mr. Feaster called you a squirrel.
I did.
Go.
They're cute. Your,
That's the best you have? All right. Oh, go ahead. That's fine.
Your Honor, we're asking that his case be set for a preliminary exam at this time.
Right. Would, people have their witnesses available the 19th? All right. Preliminary examination in this matter will be set May 19th, 2026, 9 a.m. before Judge Garwood.
And Your Honor, that Mr. Bryant's house.
That's
is
in person.
Thank you.
So you'll need to come down to the courthouse, sir.
Yes, sir. I understand.
All right. Thank you.
Thank you, Your Honor.
Have a great day. Thank you.
You too. Court calls the case People versus Trace Hickenbottom.
Good afternoon, or morning. It's morning. Good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Hickenbottom, who's approaching. Can you state your name for the court?
Trace Anthony Hickenbottom. All right. You're wishing this set for exam.
That's correct, Your Honor.
Recovery is complete.
That's correct.
Set at May 19th, 2026, 9 a.m. I think that's before Judge Garwood. Before Judge Garwood, along with the co-defendant. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus Lamar Butler.
And Assistant Public Defender Jay Bellinger on behalf of, but not with Mr. Butler. Oh, wait. Are you there, Mr. Butler? Wow. Darn.
Lamar Butler.
Unfortunately, Your Honor, my client is listed as homeless. I don't have any phone number for him, any email for him, nor do I have an address for him. So I couldn't make contact at all.
Bench warrant will issue for defendant failure to appear, bond set in the amount of 10,000, cash surety. Court does call the case People versus Cameron Larry.
Good
Morning, Your Honor. Public Defender Donovan Lee on behalf of Mr. Larry. Mr. Larry, can you tell the judge your name, please? Cameron Larry.
Thank you.
Sir, let's please set this matter for preliminary examination. Discovery is complete. Mr. Larry would like me to address the bond as well.
All right. People will have their witnesses available the 19th. Preliminary examination, May 19th, 2026, 9 a.m. before me. As to bond.
Now, with regard to bond, I think Mr. Larry has learned some important lessons over the past 30 days in jail. He understands the extreme importance of complying with this court's orders. He does have stable housing. He can stay at if he's released. Stay with his parents, at 321 Elder Street. My understanding is that they are in the courtroom today. They are aware of the case and of Mr. Larry's struggle with making good decisions regarding his bond. We have no objection to a home confinement tether. He would have a job at Home Depot that he believes he would be able to return to work. In addition, I would just note that Mr. Larry is quite young and this is his first experience with the legal system.
Response.
I think we have no objection at this point to a home confinement tether. There have been no more bond violations in the last 2 years. You know that dealers have been present at each of the hearings. I moved up, they will be filed for does resume.
Larry, if I let you out on a home confinement tether, you can follow all of the rules, right? Where are his parents? Really?
Here.
Okay, there you are. You'll keep him straight? Man, I may not want to let you go. I may have to, it might be better I keep you. All right, what I will do, your previous bond had been posted and then you messed up, right?
Yes, Your Honor.
So what I'm going to do, I'm going to reinstate his previous bond I will order that he be placed on a GPS home confinement tether prior to his release.
Thank you, Your Honor.
And then you'll be set for the 19th before me.
Thank you, Judge.
I'm gonna tell you what, you better listen to Mom. I'm looking at her right now. Uh-oh, okay. I can't see you, but I see her. Okay. All right. Thank you. We'll see you in the next. Close case. People versus Christina Eichert.
Good morning, Your Honor. Marcia Creature on behalf of Ms. Eichert, who I think is appearing via Zoom.
I thought Killerwald was here for you.
Well, you know, it caused.
You flew the first one, so you came.
Well, it caused me.
Oh, you're here. Okay, no, I'm just saying.
I was gravely concerned, so I came down here.
Okay.
All right.
The Eichert? Oh, he's in Zoom. She is in Zoom. I'm sorry.
Your Honor, I would be asking for a order for competency in this case, Your Honor.
All right, got it. I have the order here.
Yes, I prepared that ahead of Ms. Killerwald because, you know.
I do want. Forensic evaluation is ordered. I'll set a competency hearing August 6th, 2026, 9 a.m. Bond will continue. Thank you.
Oh, yeah.
Short calls case, people versus Sean Charles.
You're on reading to the people.
Morning, Your Honor. Assistant Public Defender Alexis Zerps with and on behalf of Ms. Charles, who should be appearing via Zoom. Ms. Charles, can you unmute and state your name for the record?
LaShawn Charles.
Thank you.
You're welcome.
And Your Honor, we just be requesting another, we are very close to reaching some kind of resolution in this matter.
Probable cause conference will be adjourned May 20, 2026, 9 a.m. Bond continue.
Thank you, Your Honor. Ms. Charles will be in touch.
Thank you.
Thank you, ma'am. Court calls case, people versus Robert Middleton.
And now we have Your Honor.
And Lord Yaki, Assistant Public Defender with and on behalf of Mr. Middleton. Mr. Middleton, when you get to the podium, could you state your name for the court?
Robert Middleton. Thank you.
Your Honor, there is no offer in this case. We are requesting a preliminary examination date.
All right, and discovery is complete.
To our knowledge, yes, Your Honor.
All right, people have their witnesses available the 19th. All right, preliminary examination in person will be set May 19th, 2026, 9 a.m. That's before Judge Garwood. All right, bond continued.
Thank you, Your Honor.
Court calls the case of the people versus Mario Chavez.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Chavez. Your Honor, we did not get any contact information from him at the time of arraignment. We've had no contact with him since.
So you're blaming the arraignment attorneys?
No, absolutely not.
So is this your fault?
I will take full responsibility for not getting in contact with.
You are such a noble guy. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of 10,000 cash surety. That warrant will issue immediately. Court calls the cases of the people versus Michael Moore. All five.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender with and on behalf of Mr. Moore. Mr. Moore, would you please?
Michael Spencer Moore.
Thank you.
It's my understanding from Mr. Cook that the two cases that he was going to authorize last week have been authorized.
I'm sorry.
the two cases that he said were going to be authorized a couple of weeks ago have been authorized. He's just waiting for a swear to. My client would like a global resolution, so we're asking for an adjournment of a couple weeks. So,
And are those felonies?
One of the misdemeanor that's going to 15.
Got it. Okay. You think you can get all that accomplished by the 28th? If I set it for the 28th and then,
We'll make it happen.
all right. I'll adjourn all of these out then to May 28th, 2026, 9 AM. All right. Bond will continue. So I'm gonna put that back. Court calls the case, People versus Danina Combs.
Assistant Public Defender Chelsea Virgil is with and on behalf of Danina Combs, who should be appearing via Zoom. Ms. Combs, please unmute and state your name.
Not here.
Your Honor, to be candid with the court, I have had some difficulty reaching Ms. Combs. I have no explanation for her,
So when you said you appeared via Zoom, that was a hope and a prayer?
It was optimism, yes. Yeah.
All right. Bench warrants will issue in both of those matters for defendant's failure to appear. Bond is set in the amount of 10,000 cash surety. Those warrants will issue immediately. Court calls the case, People versus Patrick Rowe.
And Alex Warren doing on behalf of Mr. Rowe.
Patrick James Rowe. Thank you.
Your Honor, I'm going to ask the court to set both matters for preliminary examination.
All right. Discovery is complete.
Believe so, Your Honor.
People have their witnesses available on the 19th. Preliminary examination in these matters will be set May 19th, 2026, 9 AM before me. Court calls case, People versus Bond continued versus, is it Hetty Diaz?
It is.
Assistant Public Defender Donovan Lee on behalf of
Good morning,
Ms.
Your Honor.
Diaz.
Hello, Miss Diaz. Can't hear
Hello,
you.
good morning. Hello.
Hello, state your name, please.
Yes, my name is Edie Diaz.
All right.
And Your Honor, we're requesting an adjournment. Ms. Diaz is sending me some additional information I'm going to be investigating.
Probable cause conference will be adjourned May 28th, 2026, 9 AM. Bond.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Stefan Scott.
Then we have the people, Your Honor.
Good morning, Your Honor. Marcia Creature staying in for the attorney of record, Mr. David I. Goldstein. Hi, how's it going? I'm just standing for David O'Brien for an adjournment. We'll be asking for an adjournment. I believe Mr. Goldstein has provided the court with the green sheet. I believe Mr. Goldstein was just retained on this matter.
He was just retained on it.
I believe so.
That's all I do have it. Mr. Goldstein.
He was here, but he had to go on a Zoom.
Yeah, but there were some dates he wasn't available.
June?
The entire month of June. All right. Then I'll adjourn this out to the 21st. May 21st, 2026, 9 AM. I do have to, because the code's effective date after the earliest date in the offense date range. Excuse me?
That's a big range.
December 19, it's not available. It's not available sometime in 2025.
Got it. Who'd you address it with?
I forwarded it to the prosecutor's office. It might have been Miss Tannock. I think she's some stuff on it.
She signed off on what?
On the it's written.
Okay. In order to enter this in our system, the charge is not available in 2019.
Correct. I'm elected.
Count 11. So on this case, count 11, which is, the malicious use of a telecommunication device involving a domestic relationship, that charge in and of itself is not available in 2019. So we can't enter count 11.
I'm gonna amend that day after two. I'll read it, this one thing after I.
Okay. All right. Just so that we get that correct, so that we can get it. All right. So I adjourned it out to the 21st. Bond will continue.
Thank you, Your Honor.
That's weird. I've seen that happens. Court calls the case People versus Jaquia Dunlap.
Judge, Tor shall seek the public defender on behalf of my client. Oh, Mr. Dunlap appears to be here, Judge.
No, my name is Jacques Dunlap. It's Jacques Dunlap.
Okay.
Thank you, Judge. We have reached out.
That was Mr. Gill's prayer.
Yes,
Oh,
it worked out for me. We had not had contact with our client this week. We asked him for an adjournment and asked him that he contact our office so we can establish contact.
I'll adjourn this out to May 28, 2026, 9 a.m. Bond continue. Mr. Dunlap?
Yes, sir.
You need to call the public defender's office.
Okay.
You got their number?
Yeah, I think so. I talked to him this morning.
Okay. Did they get a good phone number for you and a good email?
The number that I called.
Okay, do this. If you're not sure, do this. I want you to call back there. Make sure they have a good phone number and email for you so your attorneys can talk to you.
Okay, I will.
Okay?
Yes, sir.
Thank you.
No problem.
The rest of your scenes are.
The rest of them when they're ready. Court does call the case. People versus Riley Everett.
Public Defender Daffy Lee on behalf of Mr. Everett. And there he is.
Your name?
Riley Everett. And Your Honor, I'm requesting an adjournment in this matter. I did receive some additional discovery yesterday, and we're still discussing some additional discovery as well.
Public cause conference will be adjourned for 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Your Honor. No. Court does call the case. Yeah. Yours, her. Court calls case. People versus Diamond Buyers.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Ed Ladrukas on behalf of Diamond Buyers.
E45 case.
Diamond Buyers.
We know.
Thank you, Your Honor. There should be a waiver form in all files.
Waiving.
That's correct, Your Honor.
I do. All right. Spires, is that a correct statement? You're waiving your right to a preliminary examination in these matters?
Yes.
So I just want to make sure we got everything here. They're all felonies, it looks like. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing, you'll proceed to circuit court for further resolution. People also waive their right on these matters?
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on all counts. I see it. Yes, all counts are done.
Your Honor, we would acknowledge receipt of informations. We would stand mute to each charge and ask for a pretrial date. And ask for a pretrial date.
Preliminary examination having been waived, defendant waiving reading of the information, excuse me. Court will enter a not guilty plea as to all charges. Pretrial will be set for
June 29th at 1:30 with Judge Hamud.
June 29th, 2026, 1:30 before Judge Hamud.
I don't know if the court has any control over that date. I did see the co-defendants on one of these cases that the pretrial court actually would on June 1st. Is it possible to keep those together? Or is that too soon to turn around to circuit court?
I don't know. I got enough problems doing my stuff. I think what you'll have to do, I'm gonna set, this is the date, well, hold it, what do they have? Do they have an in custody date?
Yes, sir, that would be the date.
I know that. What date? That's the date her other ones are set?
Yes.
I'll do it in this case. If they give you a problem, then let me know. That way I won't answer my phone. Or I'll blame Cook. June 1st, 2026, 1:30 before Judge Hamud.
Thank you, Your Honor.
All right. Bond will continue.
What's this?
Bond continued. Thank you. Shut up, look at him. So I have to be signed job. Information. Court calls the case, People versus Lawrence Fenderson.
Good morning, Your Honor. Assistant Public Defender Alexis Zerps with and on behalf of Mr. Fenderson, who should be appearing on Zoom. I think he's there. Mr. Fenderson, unmute and state your name for the record.
Lawrence Fenderson.
Thank you.
Your Honor, my investigative team have been trying to get some video from Menards, and they've recently reached out on Monday. Still have not received an update, so we'd just be requesting an adjournment.
Probable cause conference will be adjourned June 4th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case, People versus Matthew Frazier.
The people?
Brian Bowling on behalf of Mr. Frazier, Your Honor. You state your name for the record, please?
Matthew first.
Hands on your back. Judge, I'm asking for an adjournment. Discovery.
Probable cause conference will be adjourned to May 28th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued.
Thank you, sir.
Then he goes get out of there.
Okay, I think. Okay, he's gone. Court calls case, People versus Alan Fry. Or Fife. Morning, Your Honor. Good morning.
Assistant Public Defender Lamisa on behalf of Mr. Fife. Mr. Fife, can you please state your full name for the record?
Alan Fife. All right.
My office is going to be filing a nollie in this case.
No objection, Your Honor.
No objection?
All right. No.
Case is dismissed.
Thank you, Your Honor. Thank you. Thank you all. And I'll hope to never see you.
Not hope.
Except
We'll
on TV.
never see.
What?
I say, I will never see you again except on TV.
Okay. I was about to get insulted. I don't want to see any of you people ever. I don't know what Lenise did to him. Court calls the case, People versus Filton Gloucester.
Assistant Public Defender Lamisa Gloucester, who is approaching.
Mr. Glasser, can you please state your full name for the record?
Filton Gloucester.
Your Honor, we are requesting an adjournment in this matter. Mr. Glasser has already scheduled his assessment. And I have given this off to my very capable colleague, Mr. Bowling, after today. But does want to be screened or potentially screened for.
Mess it up, Bowling.
He is not going. I believe in him. You're in good hands. Don't.
Yeah, don't freak out. You're good. May 28th, 2026, 9 a.m.
Thank you.
All right, bond continued. Thank you, sir. Court calls case People versus David Grayson.
People.
Stephanie Cannon on behalf of Mr. Grayson.
Your Honor, he just texted me. He told me he had your Zoom information, but I retexted it to him, because he says, I don't have the Zoom information, so I just sent it to him like 30 seconds ago. So he is trying to Zoom in. Yes.
What do you want me to do? Wait?
Well, I would like for you to maybe move it towards the.
Bellinger said no.
Could. And I would still ask you to do it though.
What? Of his? Yeah, well, he has more.
He does, Your Honor. A new charge was issued against him on 4/22.
Was he arraigned on it, do you know?
He has not been arraigned as of yet. I let him know about it yesterday.
Okay,
I'll try and get it.
fine, I'll pass it.
Thank you, Your Honor.
Court calls the case People versus Jamie Gurney.
I think all this for people.
What is, are those just interns packed over in the corner?
I believe so, Your Honor.
Oh. Nobody puts baby in her corner. Go ahead, what?
Good morning, Your Honor. Assistant Public Defender Davey Leib on behalf of Ms. Gurney. Ms. Gurney is standing to my right. Ms. Gurney, could you tell the judge your name?
Jamie Gurney?
And Your Honor, we'd like to this matter for preliminary examination, please, and discovery is complete.
Discovery is complete?
Yes, Your Honor.
Right. And would people have their witnesses available the 19th?
We will try for that date, Your Honor.
All right.
Thank you.
Preliminary examination, May 19th in person, 9 a.m. before Judge Garwood.
Thank you.
All right, thank you. Court calls case People versus James Heron.
And Public Defender Chelsea Ridgefield with and on behalf of Jake. Oops. Okay.
James Heron.
And I'm asking to adjourn this one as well for a plea discussion.
Probable cause conference, May 28th, 2026, 9 a.m. Bond continued. All right, thank you, sir. Thanks a lot.
I'll walk out.
You're doing those. Okay, can you just double check those? Bias. Court calls case of the People versus Hosea Hill.
Thank you, Your Honor. Alex Warren on behalf of Mr. Hill. Mr. Hill, can you state the court?
Hosea Raphael Hill. Good morning. Good morning. We're going to need to deal with this violation.
Your Honor, I reviewed that with my client. At this time, he's going to admit to not only his behavior towards.
Why was he acting that way? You're going to have to give me an explanation for that. Those folks over there at Community Corrections have to deal with a lot of people coming through, a lot of people that are under stress, and they don't need this garbage. And certainly, and I'll be honest with you, especially Ms. Dozier, does not need this garbage. So before you start talking to me, you better make sure you understand what you're saying to me.
And Honor, before the violation issued, right after the intake terminated because of behavior at the intake, Mr. Hill came to my office.
We're clear. It's not just his behavior. She had to call officers in, try to deal with it, and still tried to do it, and he still didn't do it, and he didn't complete his intake. Go ahead.
My office, made me aware of what happened. Sat down with me, wrote an apology letter to Agent Dozier, sent it to her. I extended my apologies on his behalf. And I think to try and put this into context, and he acknowledges there's no excuse for it, but to try and put it into context, Mr. Hill has had medication stolen. He's prescribed medication for a mental health diagnosis. As he scheduled 2 appointments with his psychiatrist to make a plan moving forward. And after sending our apology letter to Agent Dozier, one thing Mr. Hill brought up was if his social worker was present at the time of intake, I think that might help him regulate his emotions, but he's still trying to get back on the medication that he's prescribed. So
we'll just read the letter here.
Well, Your Honor, I can answer any of the court's questions, and I think Mr. Hill can answer any of the court's questions as well at this time.
Please, I will answer. Please. Thank you. This is difficult. Very difficult what's going on. But please, I will answer whatever you need to know from me over here. Over here. I did not expect to go to that meeting and that happened. That's for sure. I'll be open. I'm an open person. And I was just opening up to Miss Dozier about my...
No, you weren't. You were interfering with the intake process. She was just trying to get certain things done.
Can I mention something?
Go ahead.
I was talking to Miss Dozier in the meeting, and there was some confusion. I was confused, and I was explaining to her why. Because the magistrate informed me that if I go to when I go to community corrections, because he ordered me to go there, and I did everything he told me to do. And when we were in court, when I was in jail, and we were in court, he mentioned about corrections, and I already had past experience with community corrections, so I understand that these things cost money. And excuse me, please, I'm not interrupting anyone, and I don't do that. So I do, sorry. But once I was ordered to go there, I mentioned the judge in court. I said, Judge, I do not have any money. I just do not have any money, Judge. And he said, that's okay. Community corrections will not turn you away if you do not have any money. So when I went to community corrections and met with her in her office, I mentioned that to her. Because she mentioned that, I asked her, is this going to cost me? And she said, yes. And I said, okay, well, I don't have any money. And she mentioned that, excuse me, I'm trying to talk, sir. I am trying to talk.
Here's what part of the problem. Your attorney is trying to save you. Oh, you know what? Don't throw your hands down. Bond revoke, adjourn next week. Take him.
Your Honor, we can come back next week on that.
Yes.
I appreciate that.
Oh, you better keep moving. I'll adjourn this out to the 14th.
Appreciate that, Your Honor.
Here's what I'm going to do, because I think they're going to devote all their resources there, and I don't have everybody in here. Court's going to stay in recess.
All rise.
Gibson, cool.
Gonna stand up.
Bellinger, you got any more like that? No, never mind. Huh? Yeah, I think you had something to do with it. Okay, I'm doing an investigation. Court does call the case, People versus Deborah Collette.
Ballinger, Assistant Public Defender, on behalf of Ms. Collette, who appears via Zoom from the jail. Ms. Collette, can you please state your name for the record?
Deborah Joanne Collette.
Your Honor, if we may briefly approach on this?
Yes, you may.
Thank you.
So you'd like to know.
Your Honor,
Yes.
he was there. He had the old Zoom information. I gave him the new Zoom information. He came in. There was a kerfuffle, and then
A what? A kerfuffle? What is that? Find that. I don't know big words.
that's just I don't know. Said it dropped on him, and he was supposed to log back in. Is what he said.
Oh. When was that?
I don't know.
Don't text him now. Would you?
When I checked, he was in there. I looked. I made sure. And now we're here. I'm going to ask for a 1 week adjournment, Your Honor.
No.
He was here. Okay.
Is there PD in the next block or no?
Yes, I'm here all over the place.
Quit threatening me. What? Yeah. That starts at 12:30?
Yes. Early end.
So you got an hour and a half.
I'm going to say he moved you to 12:30. Be there or be in jail.
Should I make him come down here?
So here's the deal on that. Listen, I'm going to go with no, because his sister has to be the one that drives him in. And that's where the problem came in. I'm sorry, not his sister, the mother of his child. That's how come he couldn't get here in person today.
Not the same person.
I recognize that.
Okay.
Hopefully they are not the same.
Okay, I don't know. Just saying.
So he does not have a ride today. So please, if you're going to do it.
Shannon,
Yes, Judge.
if I get him in Zoom by 12:30,
Yep,
please have him have a stable connection. I'm doing this only because Ms. Fields.
Thank you, Chelsea. Thank you.
Court calls the case People versus Shantia Holloway.
Howard Yaki, Assistant Public Defender with and on behalf of Ms. Holloway, who is approaching. Can you say your name for the court? Holloway.
Thank you.
Your Honor, in terms of the next steps in the case, we are requesting that this be set for preliminary examination, but we do have a bond argument that I would like to make.
Discovery is complete.
To our knowledge, Your Honor, yes.
All right. And people have their witnesses available the 19th? I'm sorry, I didn't. Okay. Preliminary examination, May 19th, 2026, 9 AM as to bond.
So, Your Honor, Ms. Holloway is currently on GPS tether and prohibited from returning to the residence. This is obviously a allegation involving her oldest child. Her oldest child does not live at that residence currently. I verified with the DHHS worker that the child who's the complaining witness in this case.
I think I heard this the last time, didn't I?
This is her first PCC, Your Honor.
Is it? Okay. Sounds familiar.
But so the child who's the complaining witness in this case is in Pontiac with her mother, and she understands we are not asking for that.
Whose mother?
Miss Holloway's mother.
The child is with grandma.
Correct.
All right.
She's not asking, we're not asking for any contact with that child or for her to be able to go to that residence. What we're asking is for her to be able to go back to where she was living before. Her youngest daughter, who's 8 months, Aurelia, is there. And
Months old.
What was that?
Months old.
8 months old. And that's the issue. I was finally able to actually have a conversation with the DHHS worker who's investigating this, and I have some documentation here. She supports her having contact with her baby, who's not a witness in the.
Okay. What's the people's issue with? The one child is in Pontiac, or do you not know that?
No, I heard Thomas with her right was the gonna judge because the allegations are that the defendant was extremely intoxicated with the 9-year-old and the 8-month-old present, and then strangles the 9-year-old calls the police, and then it is prosecuted to the point of belligerence. And then the 9-year-old says, she's my arms critical to the point of unconsciousness. So I have concerns with, at minimum, obviously strangulation accusations, and then the fact that she was drinking so heavily while these two children are in her care, especially an 8-month-old who would need her to be sober and competent. So I think at this point I'm going to object until we move to preliminary exam and see what happens there. And then maybe reconsider her having contact with the youngest child.
May I respond, Your Honor? So, first of all, Ms. Holloway is testing on a sober link twice a day. There's been no violations. We do have documentation that she sought treatment for alcohol use. She's sober, she's clean, she's getting treatment. We have this letter from her treatment provider. We also have a couple other letters from the director of her baby's daycare in terms of
that's all fine and dandy, but CPS you're saying is saying what?
So the CPS DHHS caseworker said she supports her having contact with the baby. They're not recommending any restriction on that. They are recommending.
Well, there's a difference between having contact with the baby and caring for the baby.
That's exactly true, Your Honor.
I know, I said it.
So my understanding is, and I clarified this with Ms. Holloway, you're not going to be actually living there, staying there. You just want to be able to see her and be able to go back there.
The baby with?
Her father.
The baby's father.
Correct. So she just wants to have contact. She's not looking to live there and to actually be the sole caretaker. She's just looking to be able to see her.
Have they arranged any, I mean,
See, plan was proceedings.
Ms. Holloway's been working really closely. I do have her information. She did not give me anything in writing because it's an open investigation.
I will say, for example, that if I received some information from CPS as to this, I think I'd be willing to agree to her having like supervised visits with the child, but I just don't have any information to.
right, that's my understanding, Ms. Yagi, is you wanted her to go back there to be with and care for the child. I don't think, given what I'm hearing, that I would do that. But if there is the notion that she, and there are those that are saying she should see the child, I also don't fundamentally have a problem with that. And I think that that's probably a good thing. But it's what are the parameters of that, which is part of the problem that I'm having. I don't know what I could fashion necessarily to do that without some input as to what that contact would look like. You know, are they saying, so they're not objecting to the contact, but are they saying she should see the child once or twice a day, or are they saying, what are they saying? I don't know.
So, Ms. Holloway is saying that one suggestion she had is she has godparents who she's living with now, who one of whom is here in the courtroom. He is very supportive, but also very tough. I mean, he is very wants to make sure that everybody's safe, wants to look out for the baby. Ms. Holloway wants to make sure everybody understands.
I don't have none of that, Ms. Yagi, am I having an issue with? I just need somebody to give me a recommendation as to her seeing her 8-month-old and what that looks like.
Safety.
Yeah, I don't, because otherwise me trying to do anything, I'm stabbing in the dark, and I'm not going to do that.
Okay. Your Honor, I will develop one and I will send it to the people and seek a stipulation. And if we are able to come up with something that is, could I submit that to the court via writing, in writing for an order?
What to the court?
So for example, if I speak with Ms. Holloway and she suggests, for example, visits at a certain time, while, you know, either the child's father or her godparent is present, something like that with more specific.
If those individuals, whether it be in the form of a safety plan or there are other individuals that have put together a way that this would happen, then I'm not going to have necessarily a problem with it. I don't know that the people would either, based on what was last said, but I don't know, again, I don't know what that looks like. So I'm not agreeing that I'm going to sign anything without seeing it and seeing where it comes from. It can't come from the defendant of what she would like. It has to be something else that, well, she may like it, but somebody else is going to have to sign off on that. I'm not.
Understood, Your Honor. I will follow up with the DHHS caseworker as well, and maybe if I can get her email, you know, input, I can submit that to the people, and that might carry more weight than.
Right. Here's the other thing, though. The tether she has on is a GPS tether.
It is, Your Honor.
Do you have any indication as to what her VAC was at the time the police arrived?
I'm not sure. There's just a note that if you're highly intoxicated, it was unresponsive to questions.
Okay. So once you figure out what that may look like, the only way I'm signing off is because she's on a GPS right now. The only way I'm signing off is the other ankle gets a scram tether. Because I'm going to make sure there's no drinking.
Understood, Your Honor. I will, and Ms. Holloway wants me to make sure that I say to the court that it's the tether is interfering with her work because she has to charge it and she works in plant. And but the court it sounds like the court is not willing to remove the GPS tether at this time. But I will follow up with you and we'll seek a stipulation from the people and submit something to the court.
And all I'd say is a lot of this interferes with a lot of things that others have to do. And so I get that it's an inconvenience, but I also am aware, at least as I look at this case, that there's an 8-month-old that I'm sure you would like to see. I'm sure she would like to see you, but I'm going to put all the guardrails and safeguards in place that I possibly can before that happens. Plain and simple. Inconvenience or not. Your examination, May 19th, 2026, 9 a.m. I'm going to put that before me. Thank you.
Thank you, Your Honor.
Thank you.
Court calls case, People versus Stephen Huska.
Brian Moley on behalf of Mr. Huska. Excuse me, Your Honor. Your Honor, as you can see, Mr. Huska is not here with me. Her Vinely is in the Strong County Jail, which apparently is Bad Axe up in the thumb. I
know where Huron County is, but thank you.
I didn't know where it was.
Okay.
That's why I told you.
Okay.
And I feel that I'm pretty good at geography. So, well, regardless, Judge, I show that he's in there until September 18th.
Okay. So he's in there
It's a little while. Yeah.
All right. So why don't I be the it out to the 28th, see if we can get a writ.
Sounds great.
Yeah.
Perfect. Thanks, Judge.
Probable cause conference, May 28th, 2026. Bond.
Thank you, Your Honor.
Court calls case, People versus Jalen Johnson.
Call this for the people.
And good morning, Your Honor. Assistant Public Defender Alexi Serps on behalf of Mr. Johnson. Your Honor, can we briefly approach on this matter?
Pizza. Yeah, come on.
Your Honor, may I address bond, but prior to that, may I approach?
Yes.
Discussing.
The attorney.
Beginning June. Best of luck. Go down the hall, pay your 100. Andrew Marcus John, 26G3070224A and B. Your name, sir?
Andrew Young.
You're charged with operating while intoxicated, and you do have the right to a lawyer. I'll give you one. Do you want one? Yeah, you want one.
Yes, please.
This is a drunk driving. You don't want to play around with this. Go out in the hallway. I'll give you a court-appointed lawyer, and we'll go from there. Okay?
Thank you.
So just be patient with them. It'll take them a minute. Okay?
Yes, sir. Thank you.
Swinney. People against Chelsea, June Swinney. 26G306968.
Good morning, Judge. I'm having good feedback from this woman. Speaking of your full name.
Chelsea Swim.
All right, you got quite a breathalyzer here, young lady. Not good. All right, counsel, did you have a chance to review? So just for the record, she pled guilty to operating while impaired. The super drunk charge was dismissed, and she was referred for a screening and assessment. Have you had a chance to review the report with her, and are there any material additions, corrections, or deletions?
We haven't had a chance to review the report. There's no commission for resolutions at this time.
Anything you would like to say on her behalf?
Such as that. After talking to Ms. Sweeney, she had plenty of goals that she is currently employed at a company called Foundation Restoration as a permit releaser in a call center. She started working there on April 22nd of this year. She earns $18 an hour. She is full-time currently. And she is also enrolled in the high school diploma program through a Monroe Learning Bank. That's an online course, Judge. She started that in January of 2026 and hopes to complete it after finishing. She's got 6 more classes.
That's good.
This is her first conviction as an adult. And she's continuing to go to AA as the court ordered, and I believe she's learned her lesson, Judge, and she's assured me that this is not anything that's gonna happen again. Is that correct? Yes.
I know they're not the most. You got a larceny in 17 and 2 MIPs. So I'm not sure that should have ever been criminal. The MIPs, but still, you gotta be careful, right?
Yeah.
All right. What would you like to tell me, young lady?
That I've learned my lesson in 52 days sober. It was great.
Good.
Finished school.
Well, that's fantastic. Good. Good. And you're trying to get your GED.
No, diploma.
Diploma.
I mean, that's what I meant,
Yeah.
diploma.
Time.
I get it. Well, I'm glad you're doing that because I would have ordered it anyway, and I'm going to order it today. 13 months probation. You cannot leave the state without the consent of the court or violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You do have to report as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. I want the kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs and ETGs as follows. I'm gonna make it bi-weekly for 4 months. If you're clean, I'll then make it monthly, okay? You understand that? I want you to attend AA once a week. I'm gonna order outpatient treatment. Once you get in outpatient, you no longer have to attend AA or NA. So AA once a week until an outpatient. Once you get in outpatient, you can stop going to AA. Every time you go to AA, you have to have the form signed and you're gonna show it to probation when they have you go there.
She has to do it, Judge. You gotta order it once a week, so she did have it. She could show me.
Right, and I gathered that. And then the victims impact panel, attend that, complete that, okay? 4 days jail credit, 1 serve, 2 days on the court work program, 1 day of community service. Your community service has to be completed in this case by June the 30. 2 days court work, there's a $35 a day charge for that for a total of $70. You are to obtain and maintain employment and provide proof if they require, obtain a high school diploma or a GED. So that's perfect. 300 fines, 250 costs, 75 victims' rights, $50 justice assessment. So fines and costs here amount to $675. Probation fees are $260 for $935. Screening fees $60 for $995. Court work program fees are $70 for $1,065. And there are costs of recovery of $150. Your total here amounts to $1,215. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. Do you understand that? All right. You may be eligible for early discharge. If you do all this and there's never a violation, at least within the preceding 90 days, after 6.5 months, you can apply for early discharge, and by statute, you're entitled to it. Do you understand it? If you violate, again, you could get 93 days. You understand that? All right. How much of this can you pay today?
I just started, so I haven't gotten the first check yet.
Tell me how much you pay weekly.
Get paid bi-weekly, and I haven't got it yet.
She just started on the 26th.
I know, you're making 18 an hour, right? And you work 40 hours, right? Is that yes?
Yes.
That's 720, that's 1440. The government's gonna gladly take their share of your taxes. How about $70? Look, make it $60 bi-weekly. How's that? And I'll start that beginning June 1, but just recognize that if you do not pay and you do not show up, we're gonna issue a warrant. If you don't have the money, it's not a problem. Just call the court. We'll go on Zoom. I'll be more than happy to give you an extension, okay? Just don't ignore them. You can either walk up here or call on Zoom and I'll give you an extension. We understand one another, right? Okay, good enough. Wish you well. You'll meet with probation. Go down and you'll meet with probation across the hall. They'll explain everything to you and we'll go from there, okay? Good luck. All right. Gabby Ann Evans.
Here.
26G306739.
Just already, Judge, I'm asking if it's come back to Mr. Evans, Mr. Evans, state full name.
Yeah, Evans.
All right, this was a breathalyzer with to the tune of 119, an intoxilizer, I guess they're calling it now. What would you like to say? Is everything in this report accurate, counsel?
We have had a chance to review the report, that we have no wishes to correct the issues at this time.
All right, anything that you would like to say on Mr. Evans' behalf?
Just that Mr. Evans is 24 years old. He does have a newborn child, and he is currently living with his girlfriend. He is full-time employed. And he is in the process of actually moving into a new house, Judge, and getting his life together. This is his first conviction of any type as far as a criminal matter. And Judge, I've gone through the needs assessment. I've seen the score. I would ask the court, because of the category 1 on the alcohol, I would ask the court to sentence the fines and costs on this matter, Judge. He doesn't have any prior history with any type of alcohol conviction. And also the numbers are, the breathalyzer, Judge, was for the VAC at pieces.
He's a little young to be in here. That's all. Let it go with that. That's what bothers me on this one. I'm sure he's a nice man and all that, but I just can't justify that here. I'm not going to order outpatient, but I'm going to order a level 1 alcohol education, and we'll go from there. Okay.
Thank you, Judge.
Anything else, Mr. Gaith?
Nothing else on my part. I don't know if Mr. F. wants to-
Would you like to say anything, sir?
No.
All right.
No, but actually, so being on probation might, do I have to stay in the States? I do go, to Ohio sometimes to work on trailers.
For employment?
Yes, I'm, a mobile mechanic.
Okay. Is that the only state you go to?
Yeah.
Anything else you want to tell me?
No.
All right. 10 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance, but I will let you leave the state for employment purposes without consent of the court. You cannot violate any law, as I said. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. You're to submit to chemical testing, PBT, and ETGs. I'll note the category 1. He scored in category 1. So I'm going to make it monthly for 6 months. If you're clean, then I'll make it on demand. I'm going to make you attend. You're going to attend a level 1 alcohol education program and the victims impact panel. You're to obtain and maintain employment, provide proof of that. You're to serve 4 days jail, credit 1, serve 3. I'll let you serve those by way of community service. So 3 days of community service, I'll give you until June the 30th to complete that. You can do it at any nonprofit organization, okay? 300 fines, 250 costs, 75 victim charge fee, $50 justice assessment. So your fines and costs are $675, screening fees 60 for $735, probation fees are $240 for $935, and the cost of recovery is $150 plus attorney fees of $40. Your total is $1125. If you violate your probation, could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, and you have 14 days to apply for a court-appointed lawyer for purposes of appeal. If you cannot afford one, you understand that.
Yeah.
No kratom, no poppy seeds, no CBD oils. If those are found in your system, that will be deemed a violation. Do you understand?
Yeah.
All right. I'm going to give, you may be eligible to early discharge. So in 5 months, if you're clean and you don't have any violations within the preceding 90 days, by statute, you're entitled to early discharge. Come in here and fill out a petition. Do you understand all that?
Yeah.
All right. You have all this money to pay?
No.
How much do you have?
200.
How much can you afford to pay weekly or bi-weekly?
150. Weekly.
I'll tell you what, I'll make it 75 and I'll start that beginning June 1. If you ever don't have the money, no worries, call the court or go on Zoom on it before the due date, or you can come in here and I'll be glad to give you an extension. You just have to walk in and talk to me. Don't ignore me, okay?
Sounds good.
All right, anything else?
Nope.
Good luck.
Thank you, Ron.
Thank you, Judge.
Good luck. You're gonna meet with probation before you leave, okay?
All right.
Best of luck.
Yep.
Anthony James Fioretti, 26G306-834.
Good morning, Judge.
Anthony Joseph, you ready?
So Mr. Fioretti has done good on our sobriety court bond conditions.
Yes,
But I gotta tell you, I'm still worried about this one.
that is relatively high on the DSC.
It's not relatively high, it's over the top high. So I'm still questioning whether or not I need to send him to jail. He had a .367.
Incredibly, your honor, some actions.
Let your lawyer talk first, and I'll give you all the time you need. I'm just telling you both how I feel. I know that this is just a first or a second offense, but you got some other history going on here. You had a meth conviction, taken under 7411 just last month and a half ago, right?
Yes.
What was the offense date on that?
The date?
The offense date, not the conviction date.
Off the top of my head, I don't think.
Well, I'll check it. Hang on. I mean, I have gotten nothing but, you've been showing up for everything. You've done a good job. I'll give you that. But boy, oh boy. And you know, I mean, I promise you'd be doing a long time. But it was February 16th was the offense date. And that was after you were charged on this case, but before you had the bond set on this case. On February 26th, the bond was set. So, I mean, you've been doing great, but I got to think about this one. What do you want to say? Is everything in this report accurate? Any material additions, corrections, or deletions?
It's accurate, Judge. I've had a chance to review this report. There is no omissions, corrections, or deletions.
Is there anything you'd like to say on his behalf?
Judge, Mr. Fioretti was accepted into sobriety court. I did have a chance to review the terms of the requirements for the sobriety court. He's assured me that he's more than willing to abide by the rigorous conditions and the requirements in order to successfully complete the program. And Judge, like you said, he's been doing very well, actually, on the current.
I don't like you working in a bar either. That's another concern. At least you were honest about it. Some people aren't. But I really would encourage you to get out of there. I mean, go ahead.
Judge, he is steadily employed. He does have a 2-year-old daughter that lives with him that he does care for, Judge.
Is the mother in the child's life?
Yeah, we have split custody.
Okay, go ahead. I'm sorry. I keep interrupting.
And he does, and I believe he's genuinely remorseful, and I think this was a wake-up call for him.
Well, it wasn't too big of a wake-up call if he went out and possessed methamphetamine a couple months after this. That's where I'm going with this.
I think together, Judge, he's reevaluated his priorities at this point.
Since when?
Since having these convictions, Judge. He is currently on probation through the Third Circuit Court. That started on April 17th. He's been in compliance with that. I believe that is the other MDNH. Is that correct? That's for the other charges, the 7411. And then he also has a case out of Monroe First District Judge for a domestic violence, which he will be successfully completing. That will be dismissed, Judge. And I think everything together have brought him to the realization that he's either got to clear up his life, Judge, or he's going to end up dying of alcohol.
Yeah, where's that going to leave the 2-year-old?
That's what he's been contemplating, Judge.
Wow.
That's what's caused him to want to make a very concerted effort, at least, to get himself straight. And that's why he's asking the court to allow him the opportunity to do so. And I think he's begun, but by following his bond conditions, I believe he's making it, a very good effort. He's started. The only thing that we would ask, Judge, there is a recommendation for inpatient treatment on this case. And if he wants to go inpatient treatment, he would almost surely use his employment, his employee will not wait for him to complete that inpatient program. And he needs that income, Judge, in order to be able to pay off the fines and costs as well as the cost of living for himself and his daughter.
Call Mr. Bologna and when you have two from him. Anything you'd like to say?
Yes, Your Honor.
Make it good.
I understand, the first time I sat in front of you and you had commented on my blood alcohol level, it was a real deep hit for me. For someone to be in this profession for this long and to be shocked by the fact that I was that drunk and still operating was definitely a wake up call for me. I've made empty promises time after time to everyone around me about alcohol. I think this is the first time I'm promising this to myself. I've said, I'll do this for my dog, I'll do this for you. I'm doing this for me. The structure of the sobriety court has been exactly what I need. These AA meetings, I found some that I really enjoy. I, personally reach out to these guys and get some of their numbers, and this is exactly the structure I need. And I do believe I can be successful. No surprise to you, the court.
Is somebody calling Mr. Bologna?
I call him around. He stepped out, they said, as soon as he gets in, it's something.
"24 months probation. You cannot leave the state without consent of the court. You cannot violate any law or ordinance. You can change your address, place of employment, your home telephone number. You have to notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume anyone. You're to submit to chemical testing, PBTs, and ETGs on demand of the probation department. So they're gonna have you test 3 times a week. We're gonna start to pay for that now with our grants, so long as you test negative every time. And so long as you test every time. I can't have you just complete 60 days on the sober link. I'm gonna make it 100 more days on the sober link.
So it'll be 160 in total, Your Honor.
Well, we started February 26th, so yeah, you're gonna be on that for another 4 months.
Okay, Your Honor.
Attend AANA 3 times a week and provide written proof of attendance. Obtain an AANA sponsor. Attend all substance abuse treatment at a facility approved by probation. Attend the Victims Impact Panel. Attend and complete the Armed Specialty Court Week program. Report the status review hearings with me every 2 weeks. As you know, it's either 2 p.m. on a Tuesday or 7:30 on a Wednesday.
Yeah, I think the 7:30 is on Wednesday.
Obtain and maintain employment with proof provided to probation. I still need him. Mr. Bologna, your name?
Yeah, you can go in here.
Where is Gibraltar sending their prisoners now? Flat Rock?
Good question.
Would you go find out for me?
Yes, Your Honor.
I'm gonna find that out.
That would like up to 30 days, Your Honor.
Okay, thank you. That's all I wanted though. What days are you working? I don't like you working at the bar.
If I could add, Your Honor, they're all very aware of my
I
situation.
know, but you're still around that stuff.
Yeah. I do work in the kitchen. As soon as my shift is over, I'm out the door. There's no loitering. I work my shift. I stay in that kitchen and I'm immediately out the door as soon as my shift is done.
You know you're playing with fire, right?
But yeah, I'm taking this more seriously than I've ever taken this in my life. There.
I mean, I've gotten good reports, and all statistics tell us that these decisions that we make can often make or break somebody. "14 days jail, credit 1. It's 10 days court work program. $35 a day charge for that, for a total of $350. 3 days of community service. Community service due by August 31. Fines $200, costs $200, $75 victims' rights fee, $50 justice assessment." That's 5 1/4. Probation fees are $480 for a total of $1,005. Sobriety court fees are $360 for a total of $1,365. Cost of recovery is $225, bringing your total to $1,590 plus the court work program fees. Unfortunately, that amounts to $1,940. Heather, check my fines and costs. I'm going to tell you something right now. I don't know if I'm doing the right thing. I don't have a crystal ball. I don't have a crystal ball. But I'm telling you, you're on your rope with me. Do you understand? I mean, this is it. If you screw up one time, you are going away. The only reason I'm not sending you to jail today, if you weren't in sobriety court, you'd be going away for quite a while. I just want you to know that. So that helps. But I don't even know if I'm doing the right thing. I hope I am. This is my gut. This is what I'm doing. I think you're doing well. I don't want to set you back. Just do not disappoint me. Or we're going to really not get along. Do we understand?
I understand there'll be no surprises for you, Dr.
Well, you sound confident. That makes me feel better, I suppose.
I'm fully confident I can maintain my sobriety and be fully compliant with it.
How much of this money do you have? You need to get out of that bar, though. Why aren't you doing something better with it?
I thought we could. I mean, it's my passion.
Well, then cook at a high-end restaurant in Detroit. I'm not putting down anybody, but
No, I was thinking of it. I'd like to get to a place where I'm putting tweezers for food, you know, it's the obsession of me that loves it. But
all right,
they're very understanding of my situation.
I'm sure. You go ahead and you tell me how much you can afford to pay.
Realistically, I think I can do 100 every other week, Your Honor, with some of my other costs and the cost of rent.
I'm gonna, by the way, I'm gonna only make you do 80 days on the sober link additional after today, okay? Not 100. That's a little overkill, but I don't feel comfortable yet. You pay $75 bi-weekly and I'll start you June 1. If you need more time, you come talk to me, okay?
Yes, Your Honor.
You can either come in and talk to me after a status review. I'm gonna be really keeping an eye on you. Who are you treating with again?
Like the center?
Yeah.
It's out of the guidance center.
I know, who?
Joshua. They
Yeah.
they switched me from the single or the outpatient to the intensive, and that starts on Monday. So we went from the individuals to the intensive.
You better count your lucky stars. Get out of here before I change my mind. Go meet with probation.
Judge, I need to verify the fines and costs again. I've got two.
Yeah, I'm not doing too good with those today, huh?
I mean, I may be wrong. I might.
No,
have
you're
something
probably
wrong.
not. Let me just do it again. Now, hang on 1 second. It'll take me 1 minute here. Just let me find it. It's $200, 200 in fines, 200 costs. That's 400. 75 and 50 is 5 1/4. Probation fees are 480, so that should be 1,005. And then Sobriety court fees are $360 for $1365. Screening fee is $60 for $1425. Cost of recovery is $225 for $1650 plus. Yeah, it should be $2,000, right?
Yes,
See?
I thought you said 19 something, correct? Okay.
Yeah, I did.
Okay.
I did. I missed one of those figures didn't add in. You're all set.
Thank you.
Good luck. Stay with me now. Stay with me. I still enjoy doing this if I can help somebody. Good luck.
Thank you for your time, Your Honor.
Good luck. Do I have Ronnie Lawrence Harris Jr. here? What is he here for? Time to pay. Real quick. Come on up here. Come on, Mr. Harris. Come on up here. Tell me your name and tell me how much time you need. Your name?
Lawrence Harris.
You're 3 days late, but it's okay. Tell me how much time you need.
Maybe a month and a half.
Just to do what? You're supposed to pay it by what? May 4th?
Yes.
Paid by June the 18th. Can you do that?
Yes, sir.
If you don't have the money, what are you gonna do?
Call to the court and set up a pay rate.
You're gonna call them back here on or before that date, or you're gonna call the court on or before that date, and we are going to set up a payment plan. I have to get, okay, you understand?
Oh, yes, sir.
Good luck.
Okay.
Get, real quick, who has Stefani?
Yeah.
Come on up here. I need Beth on this. Anthony, or she's not here. Whoever I need. John, call over there quick. We got everybody waiting.
Jessica's in.
Anthony Joseph Stefani, 25W71244. Good morning.
Good morning, Judge and staff. John Graziani, attorney on behalf of Anthony Stefani. ID number 43387. Judge, I've had the opportunity to discuss this with Mr. Stefani. He's currently, as you can tell, incarcerated in the Wayne County Jail on a separate matter, and he pleads guilty, to the violations. He's failed to attend the domestic violence class, failed to pay the fines and court costs of $1,040. But a little bit of the background on this, Judge. During the time in which he was on probation here at court, he did do an inpatient program at behavioral health. I believe it's on the east side of Detroit.
I need him to state his name first. Sir, that's all right. Your name, sir?
Anthony Joseph Stefani, sir.
Hang on a second. I gotta find it. All right, give me 1 second. I would do with my arrangement. You see a stamp around here somewhere, Sadie. John, come here. Where'd I put my stamp at? You see one? I got arraignment, sentencing, the red stamp. It says arraignments.
I know, stamps right there.
All right, go ahead, Mr. Graziani.
Judge, again, for the record, he did go to the quality behavior health inpatient program for 32 days. It's located at Warren and Eastburn, on the east side of Detroit. He does suffer from a seizure disorder, which he should get out with after this is completed. And
what are you asking me to do?
Judge, I'm asking you to give him credit for time served because he has been in the Wayne County Jail. I believe it was.
I thought I told him, well, he's on other cases though. Right?
That's correct, Judge.
I thought I told him to come up. I thought we had an understanding, Mr. Stefani. Can you tell me your name again?
Anthony Joseph Stefani.
I thought we had an understanding you were to come up with the money on this case.
Yes, sir. I was in the hospital multiple times since the last time I seen you.
Why are you back in the Wayne County Jail again?
I was clearing up some old cases like you told me to. And this is from a case from 2024. I've gone to everywhere, clearing up my name, taking care of every court case that I have, doing everything I can. I went to quality behavior health.
How long have you been in custody?
What's that?
How long have you been in jail?
I was sentenced to 30 days. I get out tomorrow, so 25.
Who gave you that? Me?
3rd District.
3rd Circuit Court?
3rd Circuit, Judge Cox.
Taylor District Court, 23rd Judge.
I showed up at the courthouse after I showed up at 33rd District with proof of hospitalization improving my paycheck stubs before I came in here, trying to show you that I've been trying to do everything that I can.
Hang on.
Yes, sir.
Did you review this?
So it looks like this is Ms. Wild's case, but taking a look at it, it looks like if he did get that chart or that jail start from Taylor, it looks like she printed out, it was an operating while intoxicated third offense felony out of Taylor that I assume then went to circuit court and he got this before. That's the one she had printed out. She does have printed out that he had other charges that were filed, or a new offense, but no charges were filed out of Brownstown. Those are the only things I have in the files for him related to where he's been as of recently.
When are you gonna get your life in order, Mr. Stefani?
Judge, in fairness to him, he does, although it's not related to the alcohol charges, he does have severe health problems and he actually should be on social security disability. There's also other psychological issues that exist that really have never been addressed.
He's gonna plead guilty to these. Is that what you told me?
Correct, Judge.
All right, if you plead guilty, he doesn't have any violations on this?
Judge, the only violation involved I think he owes $1,040 for the probation fees and also failure to do a follow-up.
I saw that.
Sessions.
Did he go there at all, Jessica?
It doesn't look like it, and Judge, I have that he has at least 2 technical violations.
I thought so. So you understand, so you understand your probation could be revoked. They put 0 on this.
Gave him 3 technical violations on October 1st. And he
Also
got 2 technical violations on, it looks like December 8th.
All right.
That's fine.
I understand all the rights I covered with you. You're presumed innocent. You have the right to a hearing. They have to prove your guilt by a preponderance of the evidence. True?
True.
And you understand you could cross-examine their witnesses. You could testify or remain silent. You understand that?
Yes, sir.
By pleading guilty, you're giving up your right to a contested hearing of any kind. Do you understand that?
Yes, sir.
The charge, you failed to attend the domestic violence program with 8-week follow-up. How do you plead?
Guilty.
Did you fail to attend that program?
Yes, sir.
Is the count 2 that you failed to pay your fines and costs as ordered? How do you plead?
Guilty.
And you still owe $1,040, correct?
Yes, sir.
Anybody force you to plead guilty?
No.
Plea is accepted. So he's
Sir.
been in there.
Approximately 30 days. He was given a 30-day sentence, Judge, but he'd indicated that there were some other minor charges. I don't know if they arose out of this district court or, outside this jurisdiction. And again, I'm asking for your mercy. I really think that this gentleman, instead of additional jail time, would be better served by going into another inpatient program or even Oakdale because of a drinking issue.
Judge, I would like to know that his case does expire on June 18th, 2026.
Sir, may I say something? I did 65 days in jail with this case once already. And I'm from March 18th to the middle, from last year, from your courtroom, I did 65 days on this. And since I've been out, I've been hospitalized approximately 12 times due to a chronic seizure disorder that I keep having. But
Judge, if I may interject, I was not aware of that and my apologies.
I see where I had a date with him on February 18th. I arraigned him at 7,500, 10%. And I know he was in custody then.
When he got sentenced back in March of 2025, you gave him credit for 32 days.
Right.
But I did 65.
Well, that's not me. That was on other cases. That was not on this case.
They took me straight from your courtroom. I got arrested again. I went straight from your courtroom. And I showed up at the courthouse with my paycheck stubs and my hospitalization papers to try and show you. The clerk assured me that she would I'll let you know. I also, every drug test that I have had, including the one where I showed up here, I've passed everything, no drugs, no alcohol. I go to church, I work my job. I'm supposed to get out tomorrow and return back to work.
All right,
We
I got
spoke
it.
last time, you said get my life together, sir, I have. I walk and ride a bike everywhere, including from Flat Rock to Third District downtown. You know, I rode a bike and took buses to make sure that I'm taking care of all these things. I haven't missed anything.
I got it.
Sir, I'm really, really
I got
trying.
it. I got it. Heather. I want you to make sure you cancel that everything's taken out of lien, all the no contact provisions. Probation's revoked, you're to serve 30 days. I'll give you credit for 30. Actually, I'll make it 45 days and give you credit for those 45 days and you're all set, okay? So I'm gonna release you in terms of this case. So, but you were given a personal bond on this anyway, so you're not in custody on this case and haven't been. So we're gonna close the case with all the bond conditions out of lien and you're all set. Good luck.
Thank you.
God
Judge.
bless you. Thank you, sir.
Ahmed. Ali Abdullah Ahmed, 25T6470798 and P. Oh, boy.
Good morning, Ronald. Yeah, Ben Worley, P6489 on behalf of Mr.
Sure, your name?
Abdullah Ahmed.
All right, sorry about that, Mr. Warbling. It's just been busy here. So he's going to plead to no ops. They're going to dismiss the suspend, and he's also going to plead to impeding. They're going to set aside that default judgment where he went into default because he didn't show, and I'm certain that he's learned a lesson on that, right?
That's correct, Your Honor.
I'll set aside the default judgment on this civil infraction. You're going to plead to impeding, to that charge of impeding on that civil infraction charge, with the understanding that once you plead, the disobey stop sign would be dismissed. How do you plead?
Yes.
Responsible or not responsible? All right, and to the charge, no valid ops. If you plead to that, the possible penalties are 100 in fines, 90 days jail, costs are all those. Do you understand that? He didn't sign an advice of rights. Yes, he did. He did sign one. Did you sign, read, and understand an advice of rights form here today? If you plead guilty, you'll be giving up all those rights and we're not going to have a hearing or trial. Do you understand that? To the charge, no valid operator's license on person. How do you plead?
Yes.
How do you plead?
Yep.
Were you operating a motor vehicle in the city of Trenton, county of Wayne on December 13 of 25 on Sibley near Jefferson?
Yes, Your Honor.
Did you have a valid license with you on your person? Are you on probation or parole? Anybody force you to plead guilty? Please accept it to that charge. Please accept it to impeding. I'm dismissing the stop sign violation and the drive while suspended. I'm ready for sentence. Anything, Mr. Worbley?
Judge, there was a point in time where we thought we had a valid license, resolved the matter in Lincoln Park, we was no proof of insurance. That triggered a suspension period. And then it kind of spiraled past that to now where he's not valid until 2027. His girlfriend drove him today. He knows he can't drive, Judge, until he gets this figured out. I believe this ticket may have also, compounded the situation. That may change. But we're working with him, Judge, so that this doesn't, we gotta get him back on the road legally.
Yeah, you can't do this. Your record looks horrible. Anything you'd like to say? You gotta stop. 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 325 or 60 days, 175 on the impeding, 500 is the total. Can you pay that today? All of it? Are you sure? All right. If you're sure. Now, if you don't have the money, you call the court, we'll go on Zoom. I'll be glad to give you an extension on or before that due date. So I'm going to make it pay by May the 11th on both of these. Again, just don't ignore me. Things happen in life. If you don't have the money, it's not an issue. Just don't ignore me. You got to call up and get an extension. Okay? Good luck. Thanks a lot. Have a good day. Take care. Robert Aiken, Sunday Booth, 26T64576 A, B, and C. Good morning.
Good morning, Ed. I'm Brian Crane, who's on behalf of Mr. Booth.
Mr. Booth, your name? Boy, you're gonna get out of this one pretty unscathed, huh? Looks like, right? Right, Mr. Prane?
It's a good resolution, Judge.
For you, And for him, and I get it.
Yes.
What are you doing with your life?
Just working up.
Graduate?
Yeah.
What are you doing now?
Loan officer.
Okay, you don't want this nonsense on your record, right? So they're gonna dismiss the disorderly public intox, and they're going to dismiss the recreational use of marijuana less than 21, right? And then he's going to plead to minor in possession of tobacco, and he's going to plead to loitering. Is that right?
Yes, thank you.
All right, so you're gonna plead to two civil infractions, which isn't gonna be the end of the world. I hope you're not. I hope you're not gonna think this is okay. You don't think it's okay, do you?
No, Your Honor.
All right, to the charge of loitering, how do you plead? Responsible or not responsible?
Responsible.
And to the charge of minor in possession of tobacco, responsible or not responsible?
Responsible.
All right. I'll accept the plea to minor in possession of tobacco. I'm gonna go ahead and dismiss the marijuana recreational use. I'm gonna dismiss the public intox, and I'm gonna also accept your plea to loitering, okay? So I'm gonna just go ahead and fine him, Mr. Crane, unless you wanted to say something.
No, it's worth fine.
150 on the loitering and 135 on the possession of tobacco, okay?
Okay, thanks.
So you're gonna go, you have the money, 285?
Yes, sir.
All right, don't be doing silly things like this, okay? Have a good day. Sorry you had to wait so long, Mr. Crane.
Oh, not a problem at all. Have a good day, Your Honor.
You too.
Thank
All right, what do I have now? Justin Hurd? Is Justin Hurd here? Justin M. Hurd is not here. Going crazy. Okay. 26G307020. All right, responsible is charged by default. Didn't show, case was scheduled for 9:50. Tyler Chad Carlos, 26G306855. A and B. Mr. Stackpole, my sincere apologies. It's been busy.
Thank you, Your Honor.
I'm gonna get you out of here, I promise you. Where is Mr. Stackpole's file though? I don't even have it. Who does?
My understanding is I just spoke with Mr. Gates is that he still needs to meet with him. I thought he already met with him.
He was from a while ago.
We'll remind him. Good morning, Mr. Dubin.
Good morning, Your Honor. How you doing?
Not bad. Yourself?
Not bad. Interesting morning for you, or was it just state of the art?
Always.
Always.
All right. Your appearance?
Good morning to your staff, Your Honor. Attorney Maxwell Dubin, P number 86012. We have Mr. Carlos, who stands to my right. Please state your full name from the judge.
Tyler Chad Carlos.
All right. So you negotiated this. You want to make a record of this?
I'll be very brief here. I guess I've had the time to speak to the prosecutor's mayor and my client. He does understand his rights and the plea agreement, that plea agreement being a dismissal of the original count in the civil infraction ticket. My client would be guilty to an added count of operating while visibly impaired, and he does wish to avail himself to that offer here today.
Is that what you want to do, Mr. Carlos?
It is.
If you plead guilty to operating while impaired, the prosecutor is going to dismiss the speeding. By the way, drunk or no drunk, you can't drive like that. That's crazy.
I understand that.
And the OWI will be dismissed in the speeding. If you plead on the operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours. Community service, court costs are all those, 4 points, license suspension or revocation in accordance with your record. Your vehicle could be, or might have to be immobilized depending upon your record. You understand that?
I do.
And did you sign, read, and understand it, and vote the rights form here today?
I did.
You plead guilty, you'll be giving up all those rights, and we're not gonna have a hearing or a trial. Do you understand that?
I do.
To the charge operating while impaired, how do you plead?
Guilty.
On February 7 of 26, were you operating a motor vehicle on Jefferson near Gibraltar at 10:12 p.m.?
I was.
Did you drink alcohol prior to that, and what did you drink?
I did. I had about 5 vodka lemonades at Rivertown.
Okay, and was your ability to operate the motor vehicle impaired due to the consumption of the alcohol?
It was.
You think you were driving 82 and a 45 because of the alcohol you'd consumed?
No, I don't.
You always drive 82 and a 45?
No, I don't.
Well, then why was your,
I turned right off of Greenland right there, and the bar is right there, you know what I mean? So that's why I kind of picked up the speed, because there's cars coming, and it's tough to see. So yes, I do believe it was probably to do with the alcohol, but it was also just because I didn't want to pull into oncoming traffic, obviously.
82 on West Jefferson?
I know. And I'm from Trenton. I know how West Jefferson is.
All right, ultimately you were arrested and transported to the police station, right?
Yes.
Was this an intoxilizer, Mr. Dubin?
It was, I believe, let me be sure.
You were
I just
administered,
want to make sure it wasn't a data master or a toxilizer. Yeah, it was a toxilizer 9,000, Your Honor, and the PAC of that would be 0.159, and the defense was stipulated to that.
are you on probation or parole, Mr. Carlos?
I am not.
Anybody forced you to plead guilty?
No.
Plea is accepted to impaired driving. I find it to be an inaccurate plea. The OWI is dismissed. The speeding's dismissed. I'm going to refer you for screening and assessment. You'll be screened and assessed today. You'll come back for sentence. So the screening and assessment will take place today. You're going to go down the hall. We're going to give you a notice. What do you have for me, Heather?
May 21st at 8:30.
Is that good with you, Mr. Dubin?
Let's do it, Your Honor.
May 21st at 8:30, okay?
Okay.
So you'll go down the hall, we'll give you a paper notice, then you can go over across the hall where you'll fill out a questionnaire and be interviewed. You and your lawyer will have a chance to look at the report, okay?
Thank
When you come back. Have a great day. You have another one, counsel?
Yeah, you're to talk with me.
That's all right, Zaven.
Good for you.
That's okay. Zaven Perez, 26G306838A and B.
Good morning, Your Honor, to you and your staff, Jerry Maxwell, P number 8601, Mr. Perez, who stands to my right. Please state your full name for the judge.
All right, so this will be a plea to impaired, correct?
This will plead to impaired, Your Honor. They have time to discuss this matter with the prosecutor and my client does wish to avail himself to that offer being dismissal of all the original counts. My client will plead guilty to an added count of not guilty. Or is it amended? I'm sorry, I might have messed that up for you.
No, he didn't, oh, yes. So he's going to dismiss the PBT refusal.
Yeah, and dismissal of
Of the OWI, right? The default judgment set aside. If you plead guilty to operating while impaired, the operating while intoxicated will be dismissed, and then ultimately I will set aside the default on the impaired on the PBT refusal, and that will be dismissed pursuant to stipulation. Do you understand that?
Yes, sir.
Do you agree to that?
Yes, sir.
If you plead guilty to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all 4 points, license suspension or revocation, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, sir.
Did you sign an advice of rights today and read it and understand it?
I don't believe so. I was.
You did, the sheet that you signed upon the rights.
Oh, okay. Then yes, I didn't.
All right, you're presumed innocent. They have to prove you guilty beyond a reasonable doubt. By pleading guilty, you're giving up your right to remain silent. You're giving up your right to a trial. You're giving up your constitutional right to a jury trial. You're giving up your right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, and you're waiving the presumption of innocence and the requirement that they prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, sir.
To the charge operating while visibly impaired, how do you plead?
Guilty, sir.
On February 7th of 26, were you operating a motor vehicle on Middle Gibraltar near North Gibraltar in Gibraltar at roughly 2:03 in the morning?
Yes, sir.
Prior to that, did you drink alcohol? And if so, what did you drink and how much?
Repeat that, I'm sorry?
What did you have to drink alcohol wise and how much?
Yeah, I had alcohol. I probably had about 4 drinks,
What kind?
Jack and Coke.
What else?
That's about it.
Was your ability to operate the motor vehicle impaired because of the alcohol consumption?
Yes, sir.
In what way? Why were you pulled over by the police?
I was pulled over because I was going 40 and a 30, but honestly, I thought the speed limit was 40. There's like literally no lights there, in the street where I was at. And I just assumed that it was 40. So that's why I got pulled over.
Where were you drinking at?
I went to, River Villas.
Okay. And then ultimately you were arrested and transported to the police station.
5 minutes from my house, yeah.
And where do you live? I thought you lived in Dearborn.
No, I live in Brownstown,
What's your address?
20290 Indiana Avenue.
Okay. All right. So then you were ultimately administered a blood test, correct?
Yes, sir. I was administered a blood test.
And with the results 0.152, Mr. Dubin, you
Yeah.
stipulate that was accurate?
We stipulate the accuracy of the blood.
Are you on probation or parole?
I'm not.
Anybody force you to plead guilty or promise you anything to induce you to plead guilty?
No, sir.
Please accepted to operating while impaired. The OWI and PBT refusal are dismissed. I'm referring you for a screening and assessment, and we could do these again May the 21st, I guess, at 8:30.
Not May 22nd like the other, Your Honor?
That was the 20, no, we set it on the 21st on the,
Oh, did I screw up? I'm so sorry.
no, it's the 21st. Are you good on that?
Yeah, absolutely, yeah.
So, right, Heather, we can do another one on that date.
That's correct, Judge.
So May 21st, 2 weeks from today at 8:30. So you're gonna go down the hall, get your paper notice, go over to probation, fill out your questionnaire and be interviewed, okay? You understand everything?
Yes, sir.
And again, just to be clear, I'm dismissing the PBT refusal. Wish you well, good luck, have a good day, Mr. Dubin.
Thank you, Your Honor. Great to see you guys.
Take care,
Always such a
take care.
great weekend if I don't see you.
Thanks a lot, you too. We're gonna run you for Congress someday, Mr. Dubin.
I don't know if you guys want to do that.
Julianne McCormick. Which lawyer did you have? All right. Nathaniel David Hayes. 25T643636. So I've thought about this. I cannot in good conscience dismiss this, okay? Your name?
Daniel Hayes.
I can adjourn the review hearing to see what happens with that case, and that's what I'm gonna do, all right?
Yes, sir.
So we'll adjourn the review hearing. We're gonna give them a date in about 2 months. And I'm gonna extend probation, which I initially said was going to be 6 months. Until July 6th. So I'd like it before that date, Heather. So we'll adjourn the review the hearing. We'll make it like the last of June or something like that.
So we have June 25th, Trenton is here.
That's good. We'll make that at 9 o'clock in the morning, okay? So I'm extending your probation. I'm not assessing any additional probation fees, okay? You got it? Well, I don't want you to talk about that case. It's still pending.
No, I was saying about me missing my Zoom meeting with you.
I know, it's all right. It's okay. I believe you. I believe you. You don't have to worry about that, okay? All right, go down the hall, get your new notice, and we'll see you here, okay? So me doing what I'm doing has nothing to do with the fact that you missed that Zoom meeting. It has everything to do with the fact that you missed it as well. You shouldn't be talking about that. I'm just trying to explain to you that this has everything to do with the fact that you got charged with a new crime. Go handle it. Good luck. We'll see you back here, okay?
Thanks, sir.
Sir, in the very back, what is your name?
Oh, Harold Spowski, I'm on the docket of June.
Oh, okay, okay. As soon as your lawyer is ready, ma'am, I'll come out and handle this for
He's
you.
not in this room. He must be with that person.
Well, this is Graziani.
He's overflow. So he might be there.
Who's on my docket?
Hayes.
Is he in there, Heather? Can you tell?
I cannot tell. I can peek though. On Steph's computer. Hold on one moment.
These are the search words, so you got, let me know when you. Just on your desk. I wish, I'm just kidding.
He is sitting at the table in there. He's not up at the podium though.
All right. Is she on the bench?
She is.
All right. Well, as soon as he's called on that, what else do I have besides Mr. Stackpool? Mr. Gates is speaking to him?
Yep.
Tell those guys they can come
Boker
in.
is here. Yeah, I
Tell you
think
what.
Mr. Gates has I think he said 3 or 4.
All right. Why don't you tell those guys? Call them
What's happening on
right now. I'm gonna handle one at a time. Tell them I got 3 of them and,
Okay.
okay?
What's that?
Hey, John, that Hayes file needs to go to probation too, please.
You know, what? Who's got to go to probation?
That last one, Hayes.
Okay.
Thank
Yeah. No, ma'am, we can't do nothing till your attorney gets there. He's in the other court, so.